Delivery of order, item number 102.
For reasons mentioned in the judgment, both the civil division petitions are allowed. And the injunction granted by the First Appellate Court in respect of Schedule B property is vacated.
Item 3.
For reasons mentioned in the order, this interlocutory application seeking amendment of the memo of appeal is dismissed. The other matters are fixed on 9th of January. Go through the orders after some time.
I'll go.
Maybe, my lord, item number 30, my lord, supplementary list, my lord. My lord, in this case, my lord, I have to file my lord additional affidavit, my lord, to bring on record of the charge sheet, my lord.
Item number 30.
Yes, my lord, 30. So, my lord, this matter will be adjourned, my lord. Fixed after vacation. Yes, charge sheet submitted, my lord. I have to bring my lord charge sheet through additional affidavit, my lord. So, my lord, that this matter come.
What is the matter?
AB, my lord.
If charge sheet is submitted, you appear before the trial court. What is the offense?
Offense, my lord, 612, my lord.
61-2.
Yes.
61-2 is, what is the other offense?
Other offenses, my lord, 183, subsection 3, 126 to 118, my lord, grievous injury.
Then you appear before the trial court. Because trial court will pass orders when the matter is called up after mention.
May I please, your lord? Lord, after taking consent from the petitioner and the respondent, I beg for adjournment of item number 5 of the list. I'll file the reply, your lord, in the motion maker. Then
Item
it'll be
number
posted right after vacation.
third, Mr.
My name is, yes, your lord.
A. Nazari, learned counsel for the caveator. You are agreeing? Who prays for an adjournment and also seek leave to file a written objection against the petition filed by the petitioner. Learned Mr. B.J. Mukherjee, learned counsel for the petitioner, does not raise any objection to the prayer. Hence, same is allowed. This matter in the,
After vacation. Any time after vacation.
it will be automatically after vacation, winter vacation. The date detail. 8th of January.
Oblige, your lord.
Okay, in item number 29, we have filed our objection. Our objection may be called for.
Call for the objection.
May I please, your lordship? I will
Number.
item number 9, kindly adjourn the matter today.
Why?
My seniors have personal issues, so duties of personal issues.
You have informed the other side. You have informed. Heard, what is your name?
A. Malek,
You are for?
F.A. Lashkar.
Heard Mr. A. Malek, learned counsel appearing on behalf of Mr. F. L. Oscar, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. He further submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after Bihu vacation on a date to be fixed by registry.
Pay release, Mutton beer, item 4.
Please, Lordship, kindly adjourn the matter for the time being only, Lordship.
Why?
Engaged counsel is on legs in other court.
It is in,
Very difficult. You have to manage different courts.
no, whether case diary is there. It is go, it is charge sheeted matter.
Yes. Under 366 and 376. So let the records be called for.
Yes, you are there in this case.
Actually, I don't have any instruction. Just I have been instructed to. adjourn
Heard
the matter for
Mr.
time being.
M. Rahman,
Member.
learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. All for the scanned copy of the trial court records as well as connected case diary. The registry to take steps for requisitioning the aforesaid scanned copies. List this matter. Before,
May 20
before
earlier.
vacation. 9th January,
Sorry,
9 January.
Lordship, Sashit already filed, Lordship, and already the statement of the victim and informant already been examined. Lordship, and he's behind the bar, Lordship, for 455 days, Lordship.
We have called for a report on 9 January.
Whether in your 376 case, the victim has to be another party located. And respectfully, look, I have some doubt regarding that.
Folks,
Not POXO.
Not possible, Lordship.
you find out, go to Deepak Naik case.
So I think we have to go to that Supreme Court judgment of it.
Okay. You find out whether it is necessary or not. If it is necessary, find out before the next date fix.
Item 25 for supplementary.
Please, Lordship. Also, allegation is under section 6 of POXO.
Notice will go.
Where this states.
What is your name?
P. Dole, Lordship.
Heard Mr. P. Dole, learned counsel for the, it is a charge sheeted case.
TCR may also.
Learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days, returnable on the date due, 22nd January. Also call for the scanned copy of the trial court records as well as scanned copy of the connected case diary. Registry to take steps for requisitioning the scanned copies. List accordingly.
Pay hearing beer, item 12.
Item 12 of the CD was called for, it has not been received. Earlier, twice it was rejected, Lordship.
I kindly pass over the matter for the time being, Your Lord.
No. Heard Mr. What is your name?
A. Chaudhary, Your Lord.
Heard Mr. A. Chaudhary. You're on interim.
No,
No, Your Lord.
earlier it was rejected twice, Lordship.
Heard Mr. A. Chaudhary, learned counsel for the petitioners. Mr. B. Sharma, learned counsel for the learned additional public prosecutor. Prays for some time for production of the case diary. Prayer is allowed. Let this matter be listed. Bihur Agodhyo, 8th of January.
Lordship.
Yes.
Lordship, kindly see the last order, Lordship.
Pursuant to that order, Lordship, a status report has been received. It's in the main file itself. Lordship.
Yes, what is the submission? What is the status?
Lordship, there is- in that file itself, also there is a status report.
Yes,
Lordship, today is 1 year, 7 month, 1 day. Where earlier was for the details are out of 20.
what happened on 17th? 17th case was fixed. 17th is,
Lordship, that as per information, no taken, Lordship, Lordship exam,
no witness
Lordship,
turned up.
Lordship.
What is the next date?
Lordship,
Uh,
it was, I think, 17/12 was the last date. After
Uh,
that, not sure. Because the records are not.
Yes, Mr. Sharma, what is your submission?
Lordship, my submission will be, I've gone through the orders, Lordship, there, Lordship, somewhere, Lordship, PWs were appearing, Lordship. And somewhere, Lordship, the concerned court was on leave. And Lordship, the offences involved here, Lordship, are heinous one, Lordship. So at least it has been reflected in the status report also, Lordship, that there are number of independent witness, 6 numbers of independent witness. So, Lordship, at this stage, Lordship, at least one more direction may be given, Lordship, to examine at least the independent witness at the earliest.
Then 1 year is going on.
What is the allegation against the present petitioner?
Yes. Last is at page 16, Lordship. Page 20.
How many accused are there?
1 day, Lordship. Related,
Only one accused.
Lordship.
Murder case, Lordship, the allegation
Murder
Lordship, will find at page 28.
One Supreme Court. Values.
Page 28.
28, Lordship.
Yes,
Yes, the first paragraph itself, Lordship, prior to registration of the FIR, Lordship.
yes.
Tofiqul Ali so-and-so appeared before IC Tulsibai and verbally disclosed that in the intervening night of so-and-so at about so-and-so, he took away his girlfriend, Soniara Begum, so-and-so, towards so-and-so. They had planned to flee away to Tamil Nadu, but when they reached Bhatkuchi at about 1:30 AM on so-and-so, she changed her mind and refused to elope and wished to go back home. Being rejected, Tofiqul Ali slapped her on her face. In retaliation, Soniara Begum also slapped Tofiqul Ali. Suddenly, Tofiqul Ali caught hold of her neck and strangulated her using his both hands.
Lordship, we did terms and condition, we improved Lordship for conducting the case trial process, Lordship. And terms and condition. Is found. more than 1 year, 6 months, 1 year, 7 months, 1 day's lordship, highly considers the contract the child process lordship. Last reject order 21/5/2000.
And upon his disclosure, Lordship, the dead body was found. The Lordship will find it at page 29.
I think it's okay, lordship.
29.
Order already.
Point
Where is the earlier rejection order?
21 lordship 5. Annexure number 2 lordship,
34. Page 34, Lordship.
34 lordship. Page 34, annexure number 3. 21/5/2025 lordship. From that time, those examine lordship. Well, you see that. Page number 36, para number 14 lordship, can you see the observation? Hmm. 36, para number 14.
No, after that order, whether any other independent witness was examined,
Not taken lordship.
No,
Only
lordship.
see-
then we'll fix this case after Bihu.
Yeah.
After Bihu vacation.
Lordship.
Lordship. I'll use the silence.
Oh. Or we'll reject your prayer.
To get lordship.
No,
I'll see.
on 17th, what happened?
17, as per information that the date was not fixed pension. Yesterday, I do not contact with him. The witness was not examining lordship.
Heard Mr. Alamgir, learned counsel for the Mr. M. Alamgir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that by order dated 6/11/2024, the trial court was directed to make all endeavors to examine remaining independent witnesses as early as possible. And an up-to-date status report was called for. It appears that the status report has been furnished by has been received from the trial court. On perusal of the status report, it appears that that 8 independent witnesses are yet to be examined in this case, in the sessions case number 28/2024. It also appears that though on a few dates, 2 of the independent witnesses were present before the trial court. However, due to non-availability of the seized article, the said prosecution witnesses could not be examined. And on 26/9/2025, when the matter was listed before the trial court, the witnesses did not turn up. It also appears from the status report that the last date was fixed on 17/12/2025. However, learned counsel for the petitioner submits that on that day also, the prosecution witnesses were absent, though the summons issued to them were served on them. Learned counsel for the petitioner submits that since the petitioner is languishing behind the bars for more than 1 year, 6 months,
7 month lordship.
or more than 1 year, 7 months, he may be allowed to go on bail on the ground of prolonged incarceration. On the other hand, learned additional public prosecutor has objected to the grant of bail at this stage. He submits that since the offense involved in this case is heinous offense involving murder of a innocent girl, and since there are sufficient incriminating materials against the present petitioner on record, and the independent witnesses are yet to be examined, it may not be appropriate to release the petitioner on bail at this stage. Stop. Considering the submissions made by learned counsel for both sides, the trial court is further directed to make all endeavors to examine at least the independent witnesses as early as possible. Stop. The trial court is further directed to submit a fresh status report before this court on the next date fixed. Peace out. Let this matter be listed again on 30 January,
Can it be in the month of February, Lordship? Because
for first week of February, 6th of February. List accordingly. We'll see on that day.
Fifth.
We'll see how much trial progress on that day.
Item 27 from supplementary list.
May is a lordship.
Yes, what happened yesterday?
Yes, lordship, yesterday has happened nothing. It speaks on 29, but it is only for production, lordship. Only for production, the case has been posted on 29. No, for examining evidence, no date has been given for. That is the situation there. And lordship, just for a moment, I'd like to reiterate the brief fact, that is the incident
Your prayer was once rejected by this court.
rejected. Lordship also observed that victim should be examined. So lordship, the PO was on leave, and thereafter lordship, she did not turn up, lordship. That was the situation, lordship. And for last 6 months, petitioner behind the bar. And this affair, lordship, was lost exactly after 2 years of delay, lordship. As per the statement in the affair, it says that when my daughter was 15 years old, 2 years back, this incident has happened. And so accordingly, this when now she is 17, this affair has been lost.
What is your
And-
age? How old are you?
Let's see.
33 years.
33.
Lordship, I would like to make one short submission.
Yes,
That before he
Letter
takes
from
just two lines more, lordship.
yes.
Just for lordship, The situation was such, Lordship, after my marriage, now I'm a married person, Lordship. After my marriage, she came to my place. And when she was trying to make even few this and that, I took her to the police station. I took her to police station to control the situation, to get her back to her parents. And thereafter only, when I took her, I asked police to inform her family members. Thereafter only this affair has been lodged. And Lordship, this absconder charge sheet has been filed, Lordship, and on compliance of the summon, Lordship, on receipt of the summon, I duly appeared before the court below with an application to allow me on bail, being the local person. And that was the circumstance that I was taken into account. So my conduct, Lordship, I was not trying to evade the trial process. Rather, I duly appeared before the court with bona fide, as a bona fide citizen, with an application that has been rejected. And since then, I'm in, for last, from July, Lordship, I'm in custody. Thus, that is my rest, Lordship, let him please.
Lordship, firstly, during the investigation, he evaded. There are house search notices also there. He was not in his home, he absconded. Lordship, charge sheet was filed. And Lordship, now the thing is, Lordship, kindly go through the 183 statement of the victim. What she is stating, Lordship, is absolutely baseless, Lordship, because the victim girl is clearly in her statement is stated that there was a relationship, then she had to undergo abortion. That is different matter, Lordship. But he was already a married man, Lordship. She broke up the relationship, and after that also he is continuously harassing her. She cannot walk in the streets also, Lordship. He is pulling her dresses. That is in her 183 statement. And after the relation broke up, Lordship, she had to wait for 2 years, and she could not, Lordship, bear the harassment. After that, she filed the FIR, Lordship. Lordship, I flag marked the statement. Lordship, kindly go to that statement. Rest I leave it to Lordship.
Okay, otherwise also,
And one more thing, Lordship, the case, she has to be examined, Lordship, because apparently, Lordship, there is a threat to her. There is apparently a threat to her, Lordship.
Lordship, otherwise.
let her be
this
examined.
This case is fixed on 29. So let.
We will dismiss the bail, you pray.
Lordship, let since 29 has been fixed by the trial court for production. So what is happening on that day, we can again update, even if your Lordship fix it after this vacation.
I'm
Lordship.
stating it beforehand, Lordship. Even if,
If she examined on that particular day, then matter ends, Lordship.
no, it doesn't end, Lordship. That is what I'm submitting. Even if the victim is examined, Lordship, we'll raise our objection.
Let him
Based
taste,
on-
Lordship. Let him taste, no
Yes,
problem, Lord.
Based on that submission, Lordship, that matter cannot be kept sub judice, Lordship, for examination of the victim. Lordship will.
You
decide-
appear before the,
He is already in
Lordship.
custody.
no, you pray before the trial
Yes.
court after examination.
Yes.
After examination of the victim girl. Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. As well as Mr. B. Buragohai, learned counsel for respondent number 2, and Ms. M.K. Brown, learned amicus curiae. This application under section 183 of BNSS has been filed by the petitioner, namely Mustafa Hussain, for the second time in connection with special POXO case number 94/2024 pending before the Court of Learned Special Judge Bishwanath. Stop. The petitioner is languishing behind the bars since 22/7/2025. On an earlier occasion, when the petitioner approached this court, his prayer for bail was rejected by order dated 22/9/2025 in bail application number 2693/9/2025. While rejecting the bail application on that occasion, this court observed that it may not be appropriate to grant bail to the petitioner without examination of the victim girl, considering the facts and circumstances of this case. Stop. Learned counsel for the petitioner submits that the special POXO case
I'm sorry, Lordship. The last observation, Lordship, the petitioner may approach the trial court after victim is examined. And the court shall decide on that for law, because it will appear, Lordship, as if that after the victim girl is examined, bail can be done. Only
No.
that line, Lordship.
court will always decide as per law.
Lordship, the direction will be like after examination of the victim girl, they can approach.
Still indicates Lordship. As on today, behind our, since 257 days, Lordship. Lordship, I have taken the ground of, on ground, that is
236, 36.
36 BNS.
Yes, Mr. Sharma, you are ready?
Yes.
Half ready.
After the look.
Get full ready.
So fully the first trade on the dead day. I should not say it on officially, but Lordship, too much pressure on the last day. Anyway, sir, I can,
No, because this issue is important.
yes,
I need proper assistance.
Lordship, I have found out a judgment of the division bench of the Calcutta High Court, which goes in my favor, and there are certain other judgment, Lordship, though at this stage only that division bench judgment is missing. Because, Lordship, when the DK Basu case, Lordship, was in respect of compensation and damages, and all those are only guidelines. I can show from the judgment also, Lordship.
No, then come in the next year.
Lordship, that will be
Let-
better, Lordship.
The issue, whether any query was posed by this court on last occasion,
Lordship had indicated to me, Lordship. These
but
courts
I
are
have
not-
not indicated in the order sheet.
Yes, probably, Lordship. In any case, Lordship, that is the issue, core issue, if bail can be granted. Because, Lordship, 37 is a special statute. I mean,
No,
in the case-
query has been posed. How much contraband was involved?
Mr. Contravis is 12,000 Yaba tablets, Lordship. not
12,000
Ketamine.
Yaba tablet. Let him come prepared.
Lordship, made it, Lordship, the para of the judging, Lordship.
No, will, which judgment?
DK Basu, Lordship.
No, that we will hear, but let him come prepared.
That too, Lordship.
Not at 2, at 2 on 5th of January.
Which is all, was as on to the 257 days behind our Lordship.
Charge sheeted case.
Yes,
Lordship,
Lordship.
What is the stage of trial?
Well, it's,
Because question raised is very important. I have to either concur with the coordinate bench or disagree with the coordinate.
Let them also produce some judgment in that regard. It will also help them, Lordship.
Heard Mr. S. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though he is able to lay his hand, he's able to find out a judgment of the division bench of the Calcutta High Court in support of his contentions. However, he submits that since the question raised by this court is of prime importance and may have other consequences, may have no prime importance, stop. he may be granted some more time to submit to find out more authorities on his contention that the requirement under section 36 of the BNSS is not mandatory so as to overcome the embargo of section 37 of the NDPS Act 1985. This was your contention.
Yes.
They are saying that 36 is mandatory. If it is violated, they are entitled to get paid.
Yes, yes.
Considering the importance of the question involved in this case, the prayer for adjournment is granted. Let this matter be listed on
Can it be on 7th?
7th of January, 7th January. You also come prepared with some authorities in your support that the guidelines issued by Apex Court in DK Basu are mandatory.
So it's mandatory, as per the fair.
No, not DK Basu. Other judgments
Okay.
which say on 7th.
Published.
329.
That's it, the LCB Lord.
NCB is not.
Yeah.
Let NCB come. How many days you are behind the bars?
If,
Or let NCB come.
Lordship.
30.
May I please, your lordship?
30 charge sheet has been
Charge
laid.
sheet already.
Yes.
Heard, Mr. What is your name?
K. Alam.
K. Alam, learned counsel for the petition. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
So, I don't have the exact number.
but charge sheet has been laid
Yes, yes, trust has been laid. I will provide the number also.
bearing charge sheet number dash. In view of the fact that charge sheet has been laid, this anticipatory bail has become infructuous. The petitioner is directed to approach the trial court on receipt of summons by him, and he may pray for regular bail before the said court, if so advised. This anticipatory bail application is accordingly disposed of.
Criminal matter orders, item 32.
After some time.
Move on, item 6.
Please, my lord.
Yes.
My lord, I appeared on behalf of
Mr.
Mr.
Bhatta.
A. Ganguly, yes, who is in.
I am available.
Yes, yes.
Yes.
My lord, this is against an order passed by the appellate court whereby the rejection of plaint was reversed. We are the defendants, my lord. The present applicants are defendants. The suit pertains to a lease deed, my lord. The lease deed was executed by defendant number 1 on behalf of the company in favor of defendant number 2. The shareholders of the company challenged by filing a suit that the lease deed is illegal because of the fact that it was done by a director who did not hold any meeting for the last 10 years. and there was no proper board of directors in the company, number one. Number two, that since there was no board of directors and this director had not called any meeting, he had no authority to execute any lease deed in favor of the defendant number two. That was their allegation. We challenged it by filing an application under Order 7, Rule 11, saying that this whole matter relates to Company Law Board, which was in existence at the time when the issue arose. My lord will recall that Indian Companies Act 2013 came into force from 2013. And this suit relates to a lease deed which was executed in 2008. At that period of time, Companies Act 1956 was in existence, my lord. And such issue could have been raised before Company Law Board. After the coming into force of the new Indian Companies Act, which is of 2013, my lord, the jurisdiction of CLB, Company Law Board, has been given and assigned to NCLT. Now, the same issue can be dealt with by the NCLT, whether the legality or illegality of the lease deed is concerned or any deed. The trial court rejected the plaint, upholding our contention. The
Whether
plaintiff,
civil court's jurisdiction is barred
yes, my lord.
by
Yes, my lord.
in
So
such cases.
this was reversed by the first appellate court, my lord, holding that since the relief has been sought as regard to the legality of a lease deed, this issue could be raised only before a civil court. This judgment of the first appellate court was passed in the month of July 2025, my lord. Thereafter, the Honorable Supreme Court, by way of a judgment, has clarified. So my whole contention now is settled by the Supreme Court judgment. Mr. Datta, kindly provide the judgment so that we can straightway go to the judgment.
Where is the impugn order?
My lord.
Impugn order, page number?
It starts, my lord, at page 65. And the relevant portion, my lord, can come to para 61, my lord, at page 89, the relevant portion. Para 61, page 89. While deciding an application under Order 7, Rule 11 of CPC, the court's inquiry must be strictly limited to the plaint and documents annexed thereto. Neither the defense written statement nor any material brought in by the defendant can be relied upon. The sole consideration is whether the plaint, as presented, disclose a cause of action or reflects any statutory bar. There is no objection or challenge to this proposition of law, my lord. Para 62. In the present case, the plaintiff's private shareholders have challenged the authority of defendant number 1, who is alleged to have unilaterally executed a lease deed in favor of defendant number 2 without any valid resolution or board approval. It is specifically pleaded that the company's board had not convened for over 13 years and no authorization existed. Crucially, the challenge is directed not at the company's internal management, nor does it invoke any claim of operation or mismanagement under Section 241 or 242 of the Companies Act 2013. Instead, the issue raised is whether the defendant number 1, acting without lawful authority, could bind the company to such a transaction, a question rooted in general civil and agency law, not company law, to be dealt with by NCLT. Para 64, the jurisdiction of the civil court under Section 9 remains intact unless expressly or impliedly excluded. Section 430 of Companies Act bars civil court jurisdiction only in matters explicitly entrusted to NCLT. Since the present suit pertains to cancellation of a document executed allegedly without authority and not to any matter reserved for NCLT adjudication, the bar is not attracted. Now kindly skip para 65, my lord, 66. Therefore, the trial court's conclusion that the dispute must necessarily be tried by the NCLT solely because company property is involved is, with respect, legally unsustainable. The determinative factor is the nature of the relief sought. Kindly look the language, my lord. What is the para 66, my lord? What was going on in the mind of the learned appellate court? The determinative factor is the nature of the relief sought, which in this case pertains to the validity of a lease deed executed without authority. This falls squarely within the scope of civil adjudication and is not barred by law. So the first appellate court came to a conclusion. So far, the bar under section 430 of the new act, it doesn't operate and it doesn't preclude the civil court from adjudicating the validity of a lease deed executed by director of the company. Now kindly come to the judgment, Your Honor, which has been passed by the Honorable Supreme Court. Mrs. Shailaja Krishna versus Satori Global Limited, reported in 2025 Live Law, SC, page 866. Kindly come to para 26, my lord, page 8. It starts with a heading, my lord. There, a gift deed was under challenge before the NCLT. Page 8, my lord,
Para?
26.
Paginish, paragraph numbers are 22.
Ajanta,
Yes, page 8.
kindly help the Honorable Court. Have you
Yes,
got, my lord?
yes, yes.
Para 26, my lord. This issue pertains to, kindly look at the heading also, my lord. Preceding para 26, did the NCLT have jurisdiction to decide whether the gift deed is valid or not? This issue pertains to the central question in the current case. The gift deed has been challenged on various grounds, but before we proceed to decide on the merits, we would first decide whether the NCLT possesses jurisdiction to decide the issue itself. In so-and-so case, this court held that the CLB would be denuded of the power to provide the diverse reliefs present in the 1956 Act if the court does not give effect to the wide jurisdiction conferred on the CLB in matters concerning Section 397 and 398 thereof. The instructive passage reads as follows. Section 397 and 398 of the Act empower the Company Law Board to remove operation and mismanagement. If the consequences of refusal to exercise jurisdiction could lead to a total chaos or mismanagement of the company, would still the Company Law Board be powerless to pass appropriate orders is the question. If a literal interpretation to the provisions of Section 397 or 398 is taken recourse to, maybe that would be the consequences. But jurisdiction of the Company Law Board having been couched in wide terms and as diverse reliefs can be granted by it to keep the company functioning, is it not desirable to pass an order which, for all intent and purpose, would be beneficial to the company itself and the majority of the members? A court of law can hardly satisfy all the litigants before it. This, however, by itself would not mean that the Company Law Board would refuse to exercise its jurisdiction, although the statute confers such a power on it. Next para. It is now well settled principle that courts should lean in favor of such construction of a statute whereby its jurisdiction is retained, enabling it to mold the relief, subject of course to the applicability of law in the fact situation obtaining in each case. Now kindly come to para 29. In the landmark decision of Tata Consultancy versus Cyrus Investment, this court eruditely delineated the jurisdiction of the tribunal while passing orders on an application complaining of operation and mismanagement, which is that the tribunal ought to bring an end to the complaints of operation and mismanagement and must not only avoid providing solutions that tend to eliminate the complaints, but must also provide a solution to the problems. The relevant passages from such judgment reads as under. This is very important, my lord. Therefore, despite the law relating to operation and mismanagement undergoing several changes, the object that a tribunal should keep in mind while passing an order in an application complaining of operation and mismanagement has remained the same for decades. This object is that tribunal, by its order, should bring to an end the matters complained of. Next para. In other words, the purpose of an order, both under the English law and under the Indian law, irrespective of whether the regime is one of oppressive conduct or unfairly prejudicial conduct or a mere prejudicial conduct, is to bring to an end the matters complained of by providing a solution. The object cannot be to provide a remedy worse than the disease. The object should be to put an end to the matters complained of and not to put an end to the company itself, forsaking the interest of other stakeholders. It is relevant to point out that once upon a time, the provisions for relief against operation and mismanagement were construed as weapons in the armory of the shareholders, which when brandished in terrorem were more potent than when actually used to strike with. While such a position is certainly not desirable
Why the suit was filed?
for cancellation of the lease deed, and the allegation, my lord, was
The relief was only for cancellation of lease deed.
and eviction of the defendant, because I am in possession of the property, my lord, which was
What was your plea before?
my plea was simple, my lord, that he had the authority to execute the lease deed, number one. Number two, even if he had no authority, the matter could not be decided by the civil court. The matter ought to have been raised before the CLB then and subsequently before the NCLT. Kindly come to, my lord, for a moment, the next paragraph of the judgment where ultimately...
The judgment which you are referring to, what I understand is that if there is a relief sought against operation and mismanagement by the company, and if somebody approaches company law board, then in that, while deciding that issue, it has also power to decide other issues, other issues like validity of gift deed. But for only when the only challenge is regarding validity of gift deed, then whether civil court's jurisdiction is outside or not.
Yes, my lord, your lordship has summarized very correctly. So, lordship, can you give a look at para 30 and 31 of the judgment, and thereafter I will show two paragraphs of the plaint only. Para 30 and 31, the conclusion.
Yes.
The aforesaid decision confirmed the view that NCLT/CLB possesses a wide jurisdiction to decide all such matters that are incidental and or integral to the complaint alleging operation and mismanagement. Such power is, however, subject to any other legislative enactment specifically debarring the NCLT/CLB from exercising its power in this respect. Next para. In this 10th case, it is an admitted fact that the determination of whether the gift deed is valid or not is central to the decision herein, and therefore the NCLT did have full jurisdiction to decide whether the gift deed is valid or not, or whether it is against the provisions of 1956 Act or internal regulation of the company, including but not limited to Article of Association and the Memorandum of Association. Now, my lord, kindly see what is the allegation in the plaint. For a moment, my lord, kindly come to Annexure A. The typed portion of the plaint, my lord, starts at 26.
Page number?
26, my lord. The typed copy of the plaint.
Yes.
Page 26, capital B.
Yes.
The last valid board of directors of the company consisting of the following.
Which para you are reading?
Para 7, my lord.
Yes.
So here your lordship will find who are the board of directors and who are alive on the date of filing of the suit. So number one is Satyendra Chandra Moitra. He was the person who executed the lease deed in my favor. Second is Tushar Kanti Moitra. Till then he was alive and he filed the suit, my lord, as a director and shareholder. Now, same paragraph, that since about 10 years back, there had been vacancy of 3 directors for the proper, valid and legal board of directors, which have not been filled up as yet by due election in any annual general meeting of the company, which was always called by the defendant number 1, Satyendra Chandra Moitra, as the managing director of the company. The defendant number 1 not having called and convened any annual general meeting of the company for the last about 10 years, and the post of 3 numbers of directors still lying vacant and not filled up, proper election in an AGM, legally and literally there is no board of directors of the company since about 10 years last, and even no dividend have been declared or paid to the company's shareholders since more than last 10 years. For the defendant number 1 could not explain any reason to the company's shareholders. Next para, my lord, para 8. Instead of managing, administering, upkeeping and preservation of the company's vast immovable properties of Tezpur, particularly the Assam Valley complex at Main Road, the defendant number 1 is styling himself as a director of the said company of late during the year 2007, 2008, 2009 has been granting 99 years lease of company's valuable property without having sanction or permission or resolution of any duly elected board of directors, thereby causing irreparable harm, loss, injury, and prejudice to the shareholders. Now, my lord, what is the sum and substance of para 7 and 8? That there is total mismanagement and there is operation by one section of the share director to the other shareholders. And the lease deed is nothing but byproduct of such operation and mismanagement. Now, my lord, section.
Okay, we are issuing notice.
My lord.
Heard Mr. S.K. Singh, learned senior counsel assisted by Mr. P. Sundi. Sorry, A. Ganguly, learned counsel for the petitioner. This revision petition under 115 or 227?
It is under 115, my lord.
Under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioners impugning the order dated 14/7/2025 passed by the Court of London, Civil Judge Senior Division, Sonitpur in title appeal number 20/2022, whereby the order dated 28/11/2022 passed by the Court of Learned Civil Judge Junior Division number 1 Tezpur in title suit number 79/2010 was set aside. By the aforesaid order which was set aside, the trial court had allowed the application filed by the present petitioners for rejection of plaint under Order 7, Rule 11 of the Code of Civil Procedure in Ms. J case number 69/2022. Where is the plaint?
It starts at page 26, typed copy, my lord. Annex. Annex.
Learned counsel for the petitioners has submitted, learned senior counsel for the petitioner has submitted that the respondents had filed a title suit before the Court of Learned, Munsif number 1, Sonitpur, praying for declaration that the registered deed of lease number 1209 slash 2008 dated 30/5/2008 executed by the who is defendant number 1?
The director, my lord, one of the directors.
Executed by the defendant number 1 in favor of defendant number 2 is null and void and inoperative. The other reliefs sought for in the suit was of permanent injunction, mandatory injunction, and for recovery of
Yes, my lord. Subsequently, it was amended. Recovery of
class possession. Learned Senior Counsel for the petitioner submits that Khairuddin, the petitioners, how many petitioners are there?
3, my lord.
Who filed the petition under order 7 Rule 11?
It was defendant number 3, my lord, who subsequently died. Late Sri Tapan Ganguly.
Learned Senior Counsel for the petitioner has submitted that in the aforesaid title suit, defendant number 3, late Tapan Ganguly had filed an application under Order 7 Rule 11 of the Code of Civil Procedure, praying for rejection of the plain, mainly on the ground that the said suit is barred under Section 430 of the Companies Act, inasmuch as the matter raised in the plaint is falls within the exclusive jurisdiction of National Company Law Tribunal. Stop. Learned Senior Counsel for the petitioner submits that though the trial court had allowed the application filed by the defendant number 3 and had rejected the plaint, however, on an appeal preferred by the plaintiff, the Court of Learned Civil Judge Senior Division, by passing the impugn order, had set aside the trial court's order by observing that since
Paragraph 66. Determinative factor is the nature of release.
is the determinative factor regarding jurisdiction of the civil court is the nature of relief sought, which in the present case was found by the appellate court to be pertaining only to lease deed executed without authority, and hence it was held that it falls squarely within the scope of civil adjudication and is not barred by Section 430 of the Companies Act 1956. Learned counsel for the petitioner has submitted that in the complaint filed by the respondents before the trial court, the allegation of mismanagement and operation has been made, and further allegation against who was defendant number one?
He was
Against
one of the directors, my lord,
Against the defendant number one
subsequently died.
of the against defendant number one, that he, without having sanction or permission or any resolution of duly elected board member, had illegally executed the lease deed and caused harm to the interest of company and its shareholders. Learned counsel for the petitioner, learned senior counsel for the petitioner submits that since the allegations of mismanagement and operation has also been made in the plain, the trial court was right in rejecting the plain on the ground that the matter falls within the jurisdiction of Company Law Board / National Company Law Tribunal. Learned senior counsel for the petitioner further submits that the trial court had heard while observing in the impugned order that the question of deciding the validity of a lease deed is beyond the purview of the jurisdiction of National Company Law Tribunal. In support of his submission, learned senior counsel for the petitioner has cited a ruling of the apex court in the case of Mrs. Shailaja Krishna versus Satori Global Limited and others, reported in 2025 Live Law within bracket SC 866, wherein it was observed that National Company Law Tribunal have full jurisdiction to decide whether a gift deed is valid or not, if such question is incidental to the main question of deciding whether there was any operation or mismanagement on the part of the defendants. So he submits that in view of the legal proposition settled by the apex court in the aforesaid case, the impugned order of the impugn order is not sustainable. Stop. Issue notice to the. What has happened to the plaint? Whether plaint has been, plaint was returned to the.
No, my lord, the suit has been restored back and the matter is now fixed for evidence on the part of the plaintiff on 30th of January, 30.
Are you praying for interim also?
My lord, yes.
Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of February. Stop. In the meanwhile, considering the submissions made by learned counsel for the learned senior counsel for the petitioner, as discussed in the foregoing paragraph, further proceedings of title suit number
79 of 10.
79/2010 shall remain stayed till next returnable date. List accordingly.
Deeply obliged.
Item number 30, the charge sheet number,
Charge sheet number, what is the charge sheet number?
charge sheet number 301,
One more charge sheet number.
30125, dated 10/8/25. But in the meantime, the PRC case number also I have, Lordship, that is pending before the CJM. Should I indicate, Lordship, that
In connection with PRC case number
1093/25.
M7. Yes.
And we are before your lordships. We are a Power Grid Corporation of India, PSU, agreed by this order passed by the learned additional district of Hailakandi in miss case number so and so, directing a payment of 11,82,750 manner. This petition filed by the petitioners is under section 10 and section 16(3) of the Indian Telegraph Act. My lord, what has happened here is that the plot of the land actually doesn't belong to the petitioners. It is a disputed land. So whatever compensation has been fixed by the district authority.
Similar case was filed by you a few days ago. Whether we have dealt with a similar case.
No, my lord, that is
different.
that is regarding the jurisdiction. That we had challenged the jurisdiction.
Okay. What is the issue in this?
My lord,
case?
here what has happened is that at page 115, my lord, this is the order sheet, my lord, of the learned additional district of Hailakandi.
Page 11. 115.
115, my lord. On my lord, may kindly come to annexure
Page number.
page number 114, annexure 17, my lord. This is the order dated 29/10/2024.
Yes.
My lord, in this order, my lord, what has happened is that evidence was complete. Then the petitioners filed an application for amendment of the petition, where because in the initial petition they had not specified the number of trees or number of losses they have incurred in the process of taking over the land. Now here, my lord, at page 115 is that in the last portion, in view of the above, the petition for amendment as per the schedule mentioned in the petition stands allowed. Within a period of 14 days from today, the petitioner side shall submit amended petition plain, failing which the prayer allowed shall be treated as vacated. Now, my lord, they have within 15 days, they have submitted the amended plain. But the learned additional district Hailakandi did not adduce any evidence on the amended plane and went on to, my lord, pass the order, my lord. There's no evidence adduced on the amended plane, my lord. And in the amended plane, is more important because they've newly incorporated a number of trees and a number of plants that have been vegetables that have been uprooted.
No, which order you are impugning?
My lord, this is order dated. This is order at page 48, annexure 1, my lord. Page 48, annexure 1. my lord. And here in the order, there's no mention or no sign that, my lord, the whole petition was allowed on the basis of the amended petition. Our grievance is that, my lord, evidence should have been allowed to be adduced on some additional grounds, my lord, because these are new grounds that have been incorporated in the amended plane. And they have suppressed, the petitioners have suppressed, number one, they've suppressed that the land does not belong to them, it is a disputed land. And number two, that compensation of 9,100 rupees have already been awarded to them.
This is under which act? Telegraph?
And section 16 subsection 3 is a power of the district judge to adjudicate the matter. It's solely.
Who is the appellate authority?
Well, it is no appeal order. It is we have to come under Article 227.
There is no appeal
No,
provision.
my-
Okay. Then we'll admit this revision.
my lord.
You are sure there is no
No,
appeal?
my lord.
Heard Mr. R. Sharma. This is item number
7.
R. Sharma. Learned Senior Counsel assisted by Miss P. Fukon. Learned Counsel for the petitioner. This then you have to approach this court whether revision under 115 lies or 227.
227, and all the other petitions also we have filed is under Article 227.
No, no. Oh. Why 115 does not lie? Because in 115 there is a question of limitation.
And in some cases, 115, we have filed, we have incorporated 115, but mostly, my lord, my lords have been hearing this.
No, no. My question is not under what provision you have filed. What is the correct provision? If appeal does not lie, you have to come under 115 because 115 provides for a limitation period. If we entertain 227, there is no limitation for 227.
No,
So whether a judgment passed under Telegraph Act is not amenable to the law of limitation.
no, my lord. No, my lord.
This,
I'll satisfy you on this on the next day, my lord.
okay. This application under Article 227 of the Constitution of India has been referred by the petitioners, namely Power Grid Corporation of India Limited, impugning the judgment and order dated 4/1/2025 passed by the Court of Learned Additional District Judge Hailakandi in Miss within bracket PG case number 28/2016, whereby the petitioner was directed to pay a compensation, total compensation amount of rupees 11,82,715, along with an interest at the rate of 6% per annum from the date of filing of the petition till realization to the respondent number,
Two, my lord.
to the respondent number 2. Stop. A query was posed by this court as to whether there is any provision of appeal in the Indian Telegraph Act under an order passed by the district judge, order/judgment passed by the district judge
Under section
under
16.
section 16 of the said act. Learned senior counsel for the petitioner submits that since the act does not provide an appellate provision, hence a revision is maintainable, and accordingly the present petition has been filed by the petitioner. Stop. A further query was posed that in absence of an appellate provision, whether a revision under section 115 would lie or an application under section article 227 is maintainable. Learned counsel for the senior counsel for the petitioner submits that an application under article 227 is maintainable, and also prays for some time to satisfy this court the query posed by it by producing authorities on this behalf. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of February. Let the records of Miss within bracket PG case number 28/2016 be called for from the trial court. The registry to take steps for requisitioning the aforesaid records. Is any execution case has been
My lord, execution has been filed, my lord. My lord, may you kindly protect me until the next day, my lord.
learned since learned senior counsel for the petitioner has submitted that an execution case has all, what is the number of the
One of 2020.
execution case has already been filed by the respondent number 1 for execution of the impugned judgment and award. Some interim relief may be prayed for, may be granted to the petitioner till next reasonable date. The prayer is allowed. The execution of the impugned judgment and award shall remain stay till the next returnable date, list accordingly.
But technically, there's no prayer for stay of the execution, my lord. My lord, may kindly stay the PG case to case number 28 of 2016, my lord.
PG case cannot be stayed.
No, my lord, miss case, my lord. Miss case 28.
Miss case for
Order in miss case 28 of 2016.
order cannot be stayed. What can be stayed under 41 is the execution. only. Or we will not stay the execution.
Why not then it will give multi, because we are a public
Okay,
sector.
we are staying the execution on your oral prayer. On next date, if the other side, government is also a party,
Respondent number 1.
show the presence of,
No,
you have anything to say?
Right. But lordship.
Let the respondent number 2 appears.
Lords.
Heard
TR
Mr. T.R.
TR Gogoi.
Gogoi, London Government Council appearing for respondent number 1. পিছত issue notice of লিখিব. Since Mr. Gogoi has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2, a speed post within 7 days.
The execution, my case may be stayed, my lord, 1 of 2020.
Till next
Till
day.
next day. Oblige me.
Item eight,
What happened, my lord, the length of the plaintiff has been rejected.
Complaint was rejected.
Plaint was rejected on the ground that there is no cause of action.
You are plaintiff.
I am the plaintiff. I have filed the suit for declaration of right title interest over the suit land. And also the further declaration that the defendant has got no right over the property. Here, my lord, what happened? Your lordship,
Where is the impugn order?
impugn order 142, page number 142. No, 140, 140, 140. It start from 140. Very cryptic order, my lord. It is a vague order. So without discussing the averment made in the plain, this order has been passed. Lordship will see that order. May I read?
Yes, please read.
Both the party are represented. The date is fixed today for passing the order on the petition filed by the petitioner, defendant under Order 7, Rule 11 CPC, praying for the rejection of the plaint. The opposite party plaintiff have already filed the written objection against the petition so filed. I have heard the learned counsel for both the parties and pursue the case record and including the title suit and the document filed therein. The learned and counsel for the petitioner has contended that the instant suit is not maintainable as the plaint does not disclose any cause of action for which the plaint suit is liable to be rejected. The learned counsel for the opposite party plaintiff has won the country submitted that the petition file is without merit and should be rejected. The learned and counsel has submitted that the plaintiff have been able to show the existence of the cause of action and hence the petition should be rejected. On consideration of the plaint, it has seen that the plaintiff have instituted the suit seeking the declaration of the right title interest over the suit land, which is an ancestral plot of land which was owned by late Balindra Kumar Borua. The petitioner have claimed that the late Balindra Kumar Borua had executed a will bequeathing his property to his legal heirs and which did not include the defendant number 1, and the same was agreed to.
Okay, we'll examine the issue. We'll examine the issue.
Yeah.
We'll issue notice.
Yes.
Urge Mr. P. Upadhyay, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure has been filed by the petitioner impugning the order dated 30/8/2025 passed by the Court of Learned Civil Judge Senior Division or Junior Division? Senior Division, Kamrup at Amingaon, in Miss case number 237/2024, whereby the plaint filed by the present petitioner in title suit number 42/2023 was rejected. This rejected under Order 7, Rule 11 of the Code of Civil Procedure. The contention raised by the learned counsel by the petitioner in the instant criminal civil revision petition are required to be examined. Hence, issue notice to the respondents. Issue notice to the respondent. Only one respondent is there? No, there are
several
respondents.
main respondent.
The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode by within 7 days from the date of this order, returnable on 9th of February, list accordingly.
Item 22 from supplementary list.
Make it a lot. Lordship. Yesterday in the connecting method, Lordship issued notice, my lord. On receiver LCR, my lord. I like to place this order, my lord. So. It's the deal. Yesterday, my lord. Item number 26 yesterday.
How it is connected?
Yes, my lord. This is how it is connected. The lord will find, my lord, the order 19/11/25 did the impugn in that case, my lord, 21/12/2023, my lord. That our claim for the res judicial rejected, my lord. Subsequently, my lord, in the instant matter, my lord, 11/2/25 and 1/8/25, we prayed for a record call. Our record call petition rejected on the ground of that on 21/12/2023, our prayer was rejected on that. Therefore, relying on that impugn order, my lord, this instant impugn orders passed. So, my lord, my only humble prayer, my lord, since the both are connecting matter, LCR also received, my lord, lordship may issue notice and both the matter tied up on fixed on 2nd of February, my lord.
When the other case is fixed on
2nd of February, my lord.
2nd February.
I will place on interim on next on appearance of respondents.
Heard Mr. P.K. Deka, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Lal Bahadur Singh Chetri, impugning the order dated 11/2/2025 passed by the Court of Learned Civil Judge Junior Division, Lakhipur, Kachar,
Two impugn orders,
as well as
1/8/25,
1/8/2025
Annexure 7.
passed by the said court in connection with in this case in petition number 132 / first order was passed in which case?
My lord, first order passed in, my lord, 130/8. That is Annexure 3. The
8 means
yes, petition number 132 of /8.
8 means 2008 or
No, my lord, it is numbered. And
where is that petition?
yes, page 36, Annexure 3.
Page 36.
Annexure 3. Lordship will find very left side, my lord. And in the impugn order, it is reflected, page 44, my petition number.
Okay, PT. Kill. 8 and miss case number 6/2025 respectively in connection with title suit number 7/2020.
Yes, my lord.
Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by
Today
speed,
itself will take.
by speed post as well as by usual mode within 3 days from the date of this order,
Yes,
returnable on 2nd of February.
yes, my lord, and
Release this matter
along with my lord.
along with CRPIO number 470/2025
Deeply obliged,
on 2nd of February.
deeply obliged.
Item 23,
My lord, in this matter, my lord, I am the defendant, my lord, one money suit filed by the plaintiff, my lord, for alleging of a borrowed of rupees 3 lakhs. my lord. Then I objected filing in this file a written statement, my lord. Accordingly, my lord, lordship will find, my lord, Annexure 3 page 25. I made in one application for calling of the expert opinion to determine the age of the ink used in the signature on the hand note, page 25. And considering this application, my lord, my prayer has been considered. A very next page, page 27, Annexure 4, by this order dated 23/5/25, and also discuss why the necessary of the expert opinion in detail discussion, my lord.
Impugn order is page number.
Lordship, I'll come in order, then this order is very important to show your lordship. By this order 23/5/25, I have been allowed, and page 28, last portion I like to read, my lord. 28. The plaintiff side, bottom paragraph, my lord.
Yes.
Plaintiff said, although objected that there is no mechanism available to determine the age of ink, it will be seen once the report of the expert is obtained. But rejecting the plea of defendant solely on the ground that there is no such mechanism, it will prejudice him. Once the report is sent for the expert opinion, it will be clear as to whether any such mechanism is available or not, and the suit will proceed accordingly. Therefore, for the ends of justice and fair trial, I deem it fit to allow the prayer of the defendant. Petition number 4143 is hereby allowed. Defendant is directed. This is important, my lord. I'm agree. Defendant is directed to take steps immediately fixed on 26/25. Now, my lord, what happened? This matter fixed on 23. And defendant, I'm being allowed to take steps on the expert opinion. Let's kindly have page 29, Annexure 5. Inadvertently, my lord, what happened on 2010, my lord, when the learned counsel I engaged, he failed to check that record, failed to take steps, my lord. Then and Mike on 20, when the matter fixed, then my lord, another date fixed on 24/7. Only one day, my lord, my engaged counsel failed to take steps. Lordship, I'll come that order. This petition I have made specific ground I have taken, my lord, in the paragraph number 2, my lord. That
Where is the impugn order?
yes, impugn order, 2 impugn orders, my lord. Page 31, 17/7/25, my lord. On 17/7/25, I've made application. My application is rejected, my lord. So specific ground I have taken. My learned counsel failed to check that record, my lord. Only one day, my lord. So last month I showed this, rejected my application, my lord. Then, my lord, I'm preferred an application, review application at page 32, Annexure 7, number 1867/05. It is also rejected finally, my lord, at page 36, Annexure 8. I'm agree on this too, my lord. Date is fixed on argument, my lord. Don't discount fair justice, my lord. Interest of justice, my lord. Expert opinion is called. My counsel failed to check the record. Only one day failed to
What
check.
expert opinion?
My lord, specifically, we have taken that the hand note here challenged that there is a hand note that I borrowed rupees of 3 lakhs from him, my lord. The hand note, the plaintiff himself in the evidence is said that the ink is different. My signatures as well as the ink, signatures used in the hand note, it is totally different. On that ground, I made an application. Learned trial court has dated 23/5/25 allowed for expert opinion, and we have been directed to take steps. That is
Expert opinion to check what?
my lord,
The
to
handwriting,
age of the ink, my lord.
age of the ink.
Ink, my lord. The whole case is banned. If the age of the ink is approved, my lord, if it is, then my lord, I'll be succeed, my lord. This is the different, my lord. This is the sole issue involved. Therefore, court has fair justice considered that our prayer. But learned counsel we engaged, my lord, he failed to check the record, failed to take step. Only this ground, my lord, our petition has been rejected, my lord.
By which method age of the ink will be
My lord.
found out?
By
What is
which
the,
method?
yes,
But it will be, the expert will check in the forensic laboratory will check the ink of the age of the ink, my lord. FSL, my lord.
when is the argument fixed?
My lord, yesterday fixed, my lord. Next date when it is not in the reflected. Yesterday this matter was fixed for argument, my lord.
Yesterday, you
Yesterday.
did not argue the case.
My lord, I don't have any idea on yesterday what happened, my lord.
That is relevant.
Lordship can fix them. Sometime I will give info.
Okay.
To lordship, I will inform lordship.
Heard Mr. P.K. Dekar, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Tahir Hussain Laskar, impugning the order dated 11/9/2025, as well as
17/7.
17/7/2025, passed by the Court of London, Civil Judge Junior Division number 2, Hailakandi, in money suit number 26/2020. Issue notice to the
Sole respondent, my lord.
respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode.
Yes, my lord.
Returnable on, you give me the date,
Yes, my lord, I will give you.
then I'll give you date.
Yes, my lord. I sometime, my lord. I will.
Item 24.
May I please, my lord. My lord, here my application for implement was rejected, my lord. I'm against that order, my lord. My lord, before going to the impugned order, lordship may kindly come to the petition, my lord, file for implement. That is at page 36, my lord.
You were plaintiff.
No, my lord, the suit is at the execution stage. I have filed an application for implement as a judgment debtor, my lord. That was rejected, my lord.
You are judgment debtor.
I want to be implemented as one of the judgment debtor, my lord.
Judgment debtor, how if you are not judgment debtor?
My lord, what happened, the degree was.
You are a stranger to this suit.
No, my lord, what happened, the degree was against my grandfather, my lord. During the execution proceeding, he expired, my lord. Other legal heirs were substituted, but this petitioner is not substituted, my lord. That's why I have filed the application.
Decree is in respect of immovable property.
Specific performance of the contract. My lord, the petition is at page 36, my lord. Lordship may kindly come to page 37, my lord.
Now, what is the decree?
Decree is for a specific performance of the.
What is
contract, my
the, to whom direction was given?
direction was to earlier to the judgment debtor, my lord, who is my grandfather, to execute to perform the specific performance of the contract, to register the sale deed after receiving the, my lord, the consideration amount. my lord.
Yes.
My lord, the petition is, it starts from page 36, page 37, my lord.
Now, who was implemented in place of your
My-
grandfather?
All the sons, my lord. I
Your
am-
father is also,
My father is also included.
then you don't have a case if your father is,
My lord, my submission is that, my lord, this is the ancestral property, all parties will, my lord, comes under the
but ancestral property, you are a Hindu.
Hindu under the Mitaksha School of Law, my lord. And my lord, this property belongs to my great grandfather, my lord. So that is the ancestral property, my lord. Being a co-parsoner, my lord, I have the right. If it belongs to my father or grandfather, this is a great grandfather's property, my lord. That is inherited by them, my lord.
So you will be objecting to the execution.
No, I'm not objecting, my lord, since the decree is that.
You want share of the
Share
consideration.
of the consideration amount, my lord.
Okay.
My lord, case 37. Then the court has rejected, my lord, and mainly on the ground that since my father is already implemented, so therefore this petitioner is not required to be implemented, my lord. My lord, the case 37, if you may read the factual parts is here, my lord. The order does not reflect all the things, my lord.
You took that plea that you are a co-parsoner.
Yes, my lord. That is at page 37, if lordship may allow me to read, my lord.
Oh, okay, that was your plea.
Yes, my lord. Then, my
Yeah.
lord, page 37, paragraph 1, 2, and 3 will be relevant, my lord. I say, as I have stated that how is this property is transferred from my great grandfather to grandfather, then
In Mitakshara law, every male born becomes co-personer.
if that is an ancestral property, my lord, up to the 3 lineage, my lord. Up to the great grandfather, I can claim. After, before that, I cannot claim. My lord.
Where is the impugn order?
Impugn order is at, my lord, page 47, my lord.
At what stage the execution case is pending?
My lord, the consideration amount already they have deposited earlier in the name of my grandfather. But since that is a check, therefore the executing court directed to return back the check. And my lord, deposit the fresh checks in the name of the, my lord, all the legal heirs were impleted as the, my lord, judgment debtors, my lord. Page 47, my lord, impugn order.
Yes.
May I read, my lord?
No, you don't have any grievance against the
No, I'm
decree holder.
my lord, in the petition, I have also in the prayer portion, I have stated that I may be implicated as one of the judgment debtor. And my lord, the proportionate share of the consideration amount may be given to me. My lord. That is my prayer in the application.
What is your age?
My lord, I'm a minor, my lord, my age is, my lord, that's why I'm represented by my mother, my lord. My lord, 13 years, my lord. I'm represented by my mother, my lord. My parents are residing separately.
The check amount has already been disbursed.
No, not disbursement. My lord, if lordship may kindly come to the. My lord, earlier it was deposited in my, in the check was deposited in the name of my grandfather.
But now it has
So
been,
since he has expired, therefore they were, the decree holders were directed to deposit the fresh check, my lord.
thereafter,
Thereafter, my lord, next date is fixed on, my lord, 20/12/2025. Next date is fixed. It says, my lord, for appearance, hearing and necessary order, my lord. Amount is not disbursed till now. That is my instruction.
whom you have made party in this case?
My lord, I have
Who is the decree holder?
decree holder is, my lord, Mandavi Singh, my lord, respondent number 1. My lord.
No, why I am putting these queries? Because for your disputes, the decree holder's interest should not be affected.
My lord, in my petition, I have specifically said that, my lord, I'm not, if lordship may come to my petition, my prayer is specific. I may be implicated as one of the judgment debtor and proportionate share of the self consideration may be paid to me. That is-
Who will execute the sale deed?
My lord, now all the legal heirs are there substituted, all the legal heirs were there, my lord. They are substituted now. The sons and the wife is there.
No, whether your presence is necessary for execution of the sale deed.
My lord, since he is a minor, so therefore he cannot directly be a part in the, my lord, execute the sale deed, my lord.
Then your presence is not necessary for execution of the decree. Then the trial court is right. Your share you can claim from the judgment debtors to get your share.
My lord, my submission is that, my lord, since he is one of the co-personers, my lord. So therefore.
No, but the dispute is not between you and the decree holder. Even if suppose we issue notice, by that time the decree will be executed because your presence is also not necessary for execution of the sale deed. And mother cannot sign. So it is your father who will be signing.
Or my lord, my mother can also, my lord, sign on my behalf, my lord. Because since she is my natural guardian and both my parents are residing separately, both are not living together. And my lord, he has a right over the property, my lord. That is the main thing, my lord.
We'll examine this, but we will not stay the execution.
My lord, lordship may not stay the execution, but only one observation that, my lord, the consideration amount may not be dispersed to the judgment debtors. That much observation. Let the consideration amount be remain in the.
No, then they will not execute the sale deed.
My lord, they have already deposited, my lord, the amount in the court, my lord. That is lying before the court, my lord. Let the sale deed be executed. I do not have any objection to that, my lord. Only the consideration amount may not be released.
No. Heard. Mr. A.K. Gupta, learned counsel for the petitioner. This application under Article 227 of the Constitution of India. Under 227, writs cannot be issued.
Sorry, my lord, that is.
227 of the Constitution of India has been filed by the petitioner, Master Akshat Raj Singh, through her natural guardian, that is, through his natural guardian, that is his mother, Srimati Sumi Shah, impugning the order dated 12/11/2025, passed by the Court of Learned Civil Judge, Senior Division Tinsukia, in execution case number 4/2024. Arising out of title suit number 53/2021. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post, returnable on January after beginning. Before that, returnable on 22nd January 2025. Though the learned counsel for the petitioner had prayed for an interim relief in the form of a direction or not to disburse the consideration amount which has already been deposited by the decree holder / respondent number 1 in this case. However, this considering the nature of contentions raised by the petitioner in this case, this court is not inclined to interfere in the execution of a decree in any manner at this stage without hearing the other sides. Hence, let this matter be listed on 22nd January.
Only that observation that, my lord, consideration amount may not be dispersed. Let the execution may go on, my lord. I'm not trying to delay the execution or obstruct that, my lord. Only consideration amount, otherwise, my lord, this petition has been purchased.
If consideration amount is not disbursed, then they will not execute the decree. They will not execute the sale deed.
Because that is lying before the court, my lord. It is not that it is not paid. That is lying before the court, my lord. Otherwise, this petition will be infected, my lord, if that is dispersed and everything.
No, let the other side appear. You have, this is an application under 227.
That is, then may I pray, my lord, instead of rejecting, my let it be on the interim may be considered on the next date, my lord. Because it is almost rejecting my.
The prayer for interim relief will be considered only after due service of notice upon the respondents.
All right.
My lord, next date fixed on 6th of February.
23, 6th of February,
February.
before that day. 2nd February. Next date is on 2nd February,
2nd February, my lord.
returnable on 2nd February.
It's on item 10.
May it please your lordship. Lord, here we are challenging the order, judgment dated by Lord 18/1/24, passed by learned member MSC number 2, Kamrup at Guwahati, my lord. My lord, basically ground is that, my lord, the deceased person, he was a sub-inspector of police under the government of Assam, my lord, and he died in harness. And there, and on the basis of the circular, my lord, that is 49/27, the family members were receiving, that is on record, my lord. They were receiving the full salary, what he used to receive at the time of his death. That has come out during the examination of the official witness examined by the claimants. So on that basis, my lord, our ground is that there is no loss of financial dependency on account of the death of the deceased person.
Yes. Lord Mr. E. Kolita, learning counsel for the appellant / insurance company. Also Mr. N. Devnath, learned counsel appearing for
Respondent number lordship 1 to 5.
respondent number 1 to 5. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated dated 18/1/2024, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 514/2019. Issue notice. The appeal is admitted. Call for the records of MAC case number 514/2019 from the concerned Motor Accident Claims Tribunal. Since Mr. Devnath has appeared for respondent number 1 to 5, and since name of one M. Malik has been shown as the counsel for respondent number 6, no formal notice need to be issued to the said respondents. As regards respondent number 7 is concerned, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of February, list accordingly.
My lord, appeal copy may provide by the appellant.
The
I shall do
learned counsel for the appellant shall furnish memo of appeal, furnish a copy of memo of requisite copies of memo of appeal, requisite numbers of copies of memo of appeal along with the annexures to the learned counsel for respondent number 1 to 5 during the course of the day.
My lord, there is an IA, my lord, 4107.
Execution has been filed.
Yes, file stay petition, but I am not getting the copy, my lord.
Whether any execution case has
No,
been, no execution case has been filed. You will be objecting to this
Yes, my lord, at least 50% may be released. because
issue
Supreme Court
notice.
says-
I had notice issue karo. Almost same order. Same order.
Correspondent number 7, my lord.
corresponding missing.
Item 11,
Oblige, Lord.
Much obliged.
item number 11,
None has appeared for the appellant on call. List this matter after vacation.
item 26 from supplementary list,
Yeah, please, my lord. My lord, this is a appeal by the owner of the vehicle. I am challenging here my liability, my lord.
Heard Mr. A.K. Gupta, learned counsel for the appellant. This appeal under section 173 of Motor Vehicle Act has been filed by the appellant slash owner of the offending vehicle, impugning the judgment and award dated 14/8/2025, passed by the passed by the Motor Accident Claims Tribunal number 2, Tinsukia in MSC case number 21/2023. The appeal is admitted. Issue notice to the respondents and call for the records of the MSC case number 21/2023 from the concerned Motor Accident Claims Tribunal. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 11th of February. List accordingly.
vote here, number 41, item 14 and item 31.
Lordship, the engaged counsel in the analyze of court number 10.
Yes, Ms. Roy.
Sometime. When I have asked some urgency, when execution case is fixed on 5th of January.
Okay, we'll take, when, after how much time? After some time or after lunch? After lunch we'll.
May it please your lordship. Lordship, on the last occasion, I had been allowed to take steps by substituted service in the form of newspaper.
You have taken,
We have taken and we have filed the affidavit also.
against which respondent?
Respondent, my lord,
8.
no, 1A to 1C, 5, 6, 7, and 8. Right, it was allowed by order dated 12/11/2025.
Heard Mr. K.R. Barua, learned counsel for the, where is the new? You have filed an additional affidavit.
I have filed one affidavit, my lord. I have the copy, I'm not sure whether it has been tagged with the record.
When have you filed it?
We had filed it on, 10th of December 2025.
It is not.
I have the document number, it may be recorded in the order.
No, Putul, additional affidavit. Bring that additional affidavit on record. We'll take it up after lunch. Let the additional affidavit be placed before the record.
But I am appearing for respondent number 5, 6, and 7, that's it. Newly impleted.
Okay. No, we'll take it. As regards respondent number 8, 1A and 1C. We'll take it up at 2. Let the additional affidavit be placed before the record.
16. Item number 16.
Yes, my lord, I am from the appellant side, my lord.
Yes. Though you are not visible.
My
Yes.
lord, this is an application file under section 5 of limitation for delay condonation of 993 days, my lord. So I have filed also additional affidavit regarding the delay, my lord, which is mentioned from the paragraph number 5, 6, 7, 8, A, B, C, D, E, F, G, my lord. There is sufficient cause that there is deferred from filing the MSC appeal within the stimulated time, my lord.
What sufficient cause?
My lord, cause is mentioned, my lord, in my additional affidavit, paragraph number A, B, C, D, E, F, G, my lord. I have also annexed some medical documents from 2015 to 2024, my lord. So, my lord, it was not intentionally, but my lord, due to some medical grounds, and there is in my lord,
This is
COVID-19.
for enhancement.
Yes, my lord. Enhancements on the grounds of that, my lord. I was a driver. I was driver, and due to the accident, I became a physical disablement handicap person. So, my lord, although it was exhibited in the trial court, my lord, the same was not considered, my lord. And there was a medical vouchers of about 10 lakhs, my lord. The trial court has taken only 6,48,000 as a medical expenditure, my lord. So, my lord, due to the accident, I became a handicapped person and now unable to continue my avocation as earlier. So, my lord, that may be considered. So, my lord, this is humble request to this honorable court. Maybe please consider the delay condone and maybe please allow to contest the case on merits, my lord.
Who is appearing for the respondent side?
Respondent, there is a sole respondent, my lord, Oriental Insurance Company. And as per their objection before this, my lord, regarding the non-explanation of 662 days. So, as per order, this honorable court, affidavit regarding the delay. And I have also annexed medical documents, which is from 2024. As my lord, I was a cardiologist patient. And as per the medical documents in the annexure, my lords, which is mentioned in page number.
When is your other cases are listed for delivery of orders? There
My
are
lord, two cases, my
two
lord.
more orders of similar nature.
Yes, my lord. It was fixed on 8 January, but my lord, on that day, my several cases fixed. So this case may be fixed on 9 January, my lord.
Heard Mr. B. Ardas, learned counsel for the applicants appearing through video conferencing. None has appeared for the respondent. Let this matter be listed for delivery of orders on 9th of January 2020.
17.
Yes, my lord, I am in the item number 17. I am also the appellant side, my lord. And I have filed on one delay content petition, and which is delay of use 2,682 days, my lord. So, as the appellant is a illiterate person, she is residing in very remote area, my lord. And
Where are the, where have you mentioned the cause?
because of
Yeah.
my lord, I have mentioned that delay content cause is mentioned from the para number 7 to my lord, para number 21, my lord. 21, 22.
What is the reason?
Reason, my lord, actually, my lord, in this case, although the appellant was a medical patient, but due to the awareness of lack of awareness, she did not preserve that medical documents. So, although I have mentioned that grounds also, and also, my lord, she is a illiterate person. She don't know about of the law and fact that within the 90 days from the date of judgment, the appeal has to be filed. Although she engaged one advocate earlier, but that advocate was not filed the appeal before the honorable court. Also, after coming to know that the appeal was not filed, the appellant engaged me, and I have obtained the certificate copy, and it was filed before this honorable court.
9th of January.
Just my lord, just my lord.
Mr. B.J. Das.
My lord, B.R. Das.
B.R. Das, learned counsel for the applicant. None has appeared for the respondents. Place this matter for delivery of orders on 9th of January.
My lord, there are some similar cases which was delays as delay of 2000 above days, so which was although condoned. So I may be allowed to submit that authorities before this honorable before the.
When will you submit?
Just my lord, just my lord. My lord, on 8 January I will submit.
Not on 8 January.
January, my lord.
You submit it on 5th or 6th January.
Definitely, my lord, definitely.
Okay.
Before the registry, I will submit.
Lordship, on item number 16, I was appearing, your lordship. My presence may be recorded and my objection may be recorded, your lordship.
Okay.
Item number 16, your lordship.
Item number 16, Mr. S.A. Hussain. Mr. S.A. Hussain, learned counsel for the respondent insurance company, has objected to the prayer for condonation of delay on 9 January.
Item 18.
Yes, my lord.
May I please, Lordship? Lordship, in this IA 2698, I am the applicant. That is the claimant of the MSP. I filed this application, Lordship. Opposite affiliate insurance company has deposited 50% of the award amount. So that amount may be released.
50% has been deposited.
Yes.
Who is appearing for the other side?
Got it. This is an injury case.
Main appeal, so what has happened to appeal?
Here, the ground of main appeal is that they have exhibited two documents.
In main appeal, you are appearing for respond.
Respondent claimant. One, deposit note.
Appellant will decide it in January. We'll issue notice to the other side.
See, I have not received any notice, but from my effort, I have come to know about this case. Accordingly, I have filed my Okalatnam.
Okay.
So my name is not reflected in the cause list, though name is there in Okalatnam.
Okay. None has appeared for the, in appeal liখিব, none has appeared for the appellant on call. Mr. S. Das, learned counsel for respondent number
What?
1 has appeared and submitted that he has filed wakalatnama in this case. However, he submits that he has not received any copy of memo of appeal, and therefore he prays for directing the appellant to furnish a copy of memo of appeal. The prayer is allowed. The learned counsel for the appellant is directed to furnish a memo of appeal, copy of memo of appeal along with annexures to the learned counsel for respondent number 1. Who is respondent number 2?
Owner driver.
You are not representing.
No, no.
It appears that notice issued to respondent number 2 has not yet returned. The appellant is therefore directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days, returnable on 2nd of February. We'll decide your case on 2nd February. In interlocutory application, this interlocutory application has been filed by the claimant applicant, praying for allowing the claimant applicant to withdraw the 50% of the awarded amount which has already been deposited by the insurance company before the registry of this court. Stop. Since no counsel for the insurance company is present in the court today, let the notice of this interlocutory application be served on the learned counsel for the insurance company by the petitioner, and let it be listed again on Monday, 2nd of February, along with MSC appeal number 7/2020.
If 19,
May it please your lordship. My lord, in this second appeal, the office note has indicated that the respondent number 1, Siruddin, had died. So, my lord, I have filed an application for substitution of the heirs of the respondent number 1, and that is numbered as 3637 of 2025. Before lordship it has come. And IA civil number 3638 is for condonation of delay in bringing the heirs in time for substitution. And 3640 is for setting aside abatement.
So in 3638, which is for condonation of delay,
3638,
notice will have to be issued.
yes.
Heard Miss B. Chaudhary, learned counsel for the applicant. This application under this interlocutory application under Section 5 of the Limitation Act has been preferred by the applicants, praying for how much delay has been caused?
Delay. Delay, my lord, actually it is very difficult to count also because date of death is not known. So, my lord, in the
Which year? When he died?
delay of
In which year he died?
Actually, the report says, my lord, it came before this honorable court on 19/10/2023, my lord. Then that order indicates that there is a report from the office. And that report. Yes. This is the order, my lord. 19/10/2023. From the office note dated
But
20.
this order has been passed in RSA, main RSA. Where it has been passed, this order.
Order was passed in IS civil number 3407 of 2019.
Yes. What has been observed? What was observed?
What has been observed?
Huh?
What has been observed?
What has been
Observed.
observed? The observation is that the response number 1 has expired and the response number 2 to 6 have refused service. As
No date has been mentioned.
no date.
Okay. Delay. কি লিখলে? Praying for condonation of delay in. You have also filed an application for setting aside abatement. Praying for delay in filing application for setting aside abatement of the appeal on date of respondent number 1. Learned counsel for the applicant has submitted that since the exact date of the death of respondent number 1 is not known to the applicant, the exact period of delay is not mentioned in the instant application. She further submits that the present applicant came to know about the death of the respondent number 1 only on perusal of the order dated 19/10/2023 passed in IA civil number 3407/20. Year is
Your Honor, 2019.
2019. Start. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order.
My lord, because the appeal is dismissed for dismissed in the year 2012, my lord. And so many missed cases before lordship. I'm tired because one after another response has expired. And my lord, appeal nobody appeared. If the appeal was fixed for ex parte hearing, and on that day, appellant's counsel, learned senior counsel, P.R. C.K. Sharma Boro was no more. So there was no representation. Thereafter, when the petition was filed by another senior counsel during that pendency, that senior counsel also died, my lord. His junior also died. So many missed cases.
But we are helpless.
Yes, my lord, may I pray that in all the missed cases, notice should go because condone.
No, if we condone the delay, first we have to condone the delay.
Yes.
We may dispense with the notice in other cases. But for condonation of delay, notice has to go.
Has to go.
Let this matter be listed on 11th of February,
Okay, February.
2026.
I'm obliged. My lord, item 33 has come before lordship on my prayer for moving a petition for modification of your lordship's order. And it has come. May I pray for taking it up, my lord, because if paucity of time does not permit, then my lord, my petition will become meaningless.
We'll take it up at 2.
2 o'clock, my lord. I'm deeply obliged. case, the applicant with the murder of Master Koirav Datta Medhi has not been able to meet her minor elder son properly for almost 23 months, except for one occasion when such a visitation right was granted by the family court on 23/2025 for a few hours. There cannot be a dispute regarding the proposition that the minor elder son of the party, Master Koirav Datta Medhi, has a right to have love and affection of both the parents, and denial of the same would not be in the best interest of the child. My humble submission before Lordship that for almost 23 months, that was rebutted by me in my affidavit in opposition, and thereto no reply has been made by my learned friend. So my lord,
What change you want?
my changes, in my petition, I have stated that for 11 days, my lord, whenever the
No,
case-
what alteration you want?
my lord, my apprehension is that as the guardianship matter has not been decided as yet by the learned trial court, your lordship's observation may have some impact. That is why
It will not have any impact.
that, because 23
I
months,
have
my
made
lord,
it clear in the order itself somewhere.
23 months, my lord, that is not, it's not based on a record, my lord, because my affidavit and in my petition also today, this petition also for 11 times, when the case was fixed before the learned family court, she had the opportunity to meet the child. And in my affidavit to the civil revision petition also, I have annexed various documents. That portion may be deleted, my lord. And because the divorce case is also there, my lord.
No, I'll dispose of this matter with an observation that
23 months.
that the custody matter will be decided by the trial court on its own merits.
Lordship, my only thing is this IA has not been filed for that, your lordship, because in the prayer, if you kindly go through the prayer.
What is the price?
They
There
have
is some
not-
other price.
Prayer, specifically, they said limited. They told me when they were filing
What
this,
is the prayer?
there is, no- if may I read it, your lordship? In the aforesaid premises, it's page 10 of their petition.
No, what is the prayer in the instant?
I'm reading, your lordship. In the premises aforesaid, it is therefore respectfully pray that your lordships may be pleased to admit the application, issue notice to the opposite party wife to show a cause as to why the order dated so-and-so passed by this honorable court on their application bearing so-and-so in so-and-so CRPO shall not be modified or altered as prayed for. And upon hearing the cause, if shown any
limited-
and on
that is
limit,
there, my
on
lord.
on
Limited
perusal
extent.
of record may further be pleased to modify and or alter the order dated.
Just
limited
a
extent.
To a limited extent, it is.
Your
written, my
lordship, when,
I'll
if I may say,
I'll come to you.
yes, your lordship.
To a limited extent.
Where is that modification which you are seeking?
My lord, it is there, my lord. After 9/12 to a limited extent, my lord. I am not seeking, because this order, your lordship has been pleased to allow visitation like that. We are not, because of this observation, my lord, have become a bit apprehensive. I'm afraid that this
No, that may not be a reason for reviewing.
23 months, my lord. So that.
No, let me understand. Where is your specific prayer for modification?
Specific prayer, my lord, because in my paragraph on my content, under my contention, my lord, it was stated.
No, that I have understood that it is not 23 months according to you. But where is that prayer where you are seeking what is to be modified? Read prayer portion again.
The cause title itself, my lord, in the cause title itself, I have stated that praying for modification and or alteration of an order passed by this honorable court. I am not, my lord, I have no audacity to challenge the order. My only thing that under paragraph 18, my lord, is lordship's order. That is fixed.
On 27, she will be filing objection. We'll hear it and try to dispose it off on that day.
I have to give an advance copy of the objection.
This time I'll have to bear the expenses, my lord.
Yes.
Obliged. I have a feeling, my lord, if she goes once, maybe there is a possibility of some reunion also. That was my feeling.
Later on, she
Lordship is
will,
exempt, lordship,
Let-
exempt, lordship.
later on, she will go.
That problem now. It has become a problem.
Because
The problem, social problem.
during, there is an observation that during the pendency of the custody application, none has appeared for the applicant on call. Mr. B. Sharma, learned counsel for the learned additional public prosecutor is present. What to do?
Last occasion also, okay, they were
Last two occasions,
maybe close. For non-prosecution.
it appears that on last two consecutive dates, when the matter was called for hearing, no one has appeared for the applicant slash petitioner on call. This court is therefore of the view that the petitioner is not inclined to pursue this matter. This interlocutory application is accordingly dismissed for non-prosecution.
29.
May it please the Lord. Lordship, I have been arrested on.
Now it has again come to this court.
Yes, Lordship.
Probably registry has given a note also.
Okay, what is your submission?
Lordship, I was arrested on 4th of September 2025. It means 106 days. And 3 months, 15 days till today I have been in the behind the bar. Lordship, there are 3 accused persons in this case. One is Santosh Kumar, Tamil Silvan, number 2 Rakesh Ahmed, and third Zahia Khan, that is me. Tamil Silvan, all the accused persons are CRPF personnel. Tamil Silvan and Rakesh Ahmed, both are posted in Manipur. And me posted in Agartala, Lord. On 25th of September 2025, the first accused, Santosh Kumar, was arrested in Hujai railway station, Lord. With 33.667 kilograms of Yaba tablets were recovered from him. Then on the basis of the confession statement of the first accused, that means Santosh Kumar, Rakesh Ahmed was arrested from Manipur, Lord. And after 42 days of their arrest, that means the seizure, that is on 4th of September 2025, I was arrested from the Guwahati airport. And nothing was recovered from me. I was arrested after 42 days of the seizure, and on the basis of the co-accused Rakesh Ahmed's statement, Lord, confession statement. Lordship, on the day when the seizure was made at Hujai railway station, Lordship, that is 25th of September, I was discharging official duty in Agartala, Lordship. Lordship, kindly come to the page number 17, Lordship. This is the duty register, Lordship. The serial number, the first part, serial number 9, Lordship.
It is a charge sheeted case or
No,
it is investigation is going on? Okay.
Lordship,
106 days. Agency.
Yes.
that is serial number 9, the first part, Lordship, first paragraph, Zahia Khan. It means I was on duty. This is on 23rd, Lordship. 1300 hours to 1900 hours. That means 1 PM to 7 PM, Lordship. On 23rd, Lord. Next, on 24th, Lordship, I was on duty in the morning, 6 hours to 1300 hours, that means 1 p.m. at noon, Lordship. Then again on the same day, I was discharging my duties, 1900 hours to next day, that means 6 a.m. Lordship. That means 25th, Lordship, on the next day, Lordship. On 25th, I have been granted casual leave, and that is why I left from Salbagan, that is Tripura Agartala, CRPF campus at 1349 hours. That is 1 p.m. 49 minutes, Lordship. I have left. That is on 25th. And seizure was made on 25th at midnight. That means time is 1:40 hours to 10 hours. That means midnight 1:40 to 10 hours.
Seizure was made on which date?
25th, Lordship.
25th of what?
25th of July, Lordship. 25th of July, Lordship.
At what time?
1:40 to 10 a.m. 1:40 a.m. to 10 a.m. between.
From where the seizure was made?
Pujai railway station. Lordship.
Railway station.
Pujai railway station. From Santosh Kumar, Lordship, the first accused, Lordship, not from me. Nothing was recovered from me, Lordship.
Okay.
So
Yeah.
here the prosecution has said that I am the supplier, Lordship. Lordship, I was not present. I was discharging my official duty in Agartala. So how I would be the supplier. Now the allegation comes on me that two allegations. This is regarding CDR, and one more allegation is on against me. This is that regarding the bank transaction, Lordship. The prosecution has failed to place on record any CDR without voice records, Lordship. Prosecution has not submitted any voice records or money trails or money. Without voice record, the CDR is not sufficient, Lordship, to prove my case, Lordship. That I will support by the case of the Jammu and Kashmir High Court. Para number 15, Lordship, page number 9, Lord. Page number 9, Lordship. May I read, Lordship?
No, why you were arrested? On the basis of
Confessional statement and
Confessional
professional relation with me. All are CRPF accused.
confessional statement, the other accused implicated you. Thereafter, CDR record shows that you were talking to them.
CDR has been
And-
stating by the prosecution, but CDR, how, at what time?
No, but it is still under investigation.
Yes, investigation. But as far as my knowledge, no details have been given, Lordship. Only CDR. What CDR, Lordship? Nothing has been mentioned. Any voice record is not mentioned, not provided, Lordship. And whether I have called my co-accused on that day or 3 months before or 1 year before, they are my professional colleague. I may call him. I may have the transaction with them, but on that day or within 1 week, whether I contacted with them or not, Lordship. That is the matter, Lordship. I may contact him before 1 year, 6 months before. That is not relevant, Lordship. That has been.
What is there in para 15 which you are referring to?
I'm reading, Lordship. The only material that connects the petitioner to the alleged crime that is left is the CDR, which has been collected by the investigating agency during the investigation of the case. As per analysis of the CDR, it appeared that the petitioner was in touch with the co-accused during the relevant period. The question arises as to whether the same would be sufficient to prima facie hold that the petitioner guilty of having committed the offense for which he has been booked. In the opinion of this court, CDR details showing contact between the petitioner and co-accused without there being any voice recording relating to the conversation between them may not be sufficient to convict the petitioner for the offense for which he has been booked.
Lordship. This is the bail application and the bail has been granted to that person, Lordship. Then the next allegation is,
So
Lordship,
your submission is that mere fact that you contacted with the co-accused is not enough
yes, Lordship,
unless the content of the conversation is
voice recorded is not furnished.
voice recorded. Otherwise, what was conversed between you and the co-accused, that is more relevant.
But Lordship, what time I contact with them? What is the time? Whether on that day or within 1 week or 1 year before?
Okay.
I am the
yeah,
professional.
Okay, your submission is that what was the conversation that is more relevant?
Yes, Lordship.
Mere fact that you had spoken to
I
him.
may have the friendship relationship also,
Okay.
Lordship.
Okay, what else?
The next allegation that is regarding the bank transaction, Lordship.
Yes.
Bank transaction, regarding the bank transaction, Lordship.
Bank transaction means money was deposited in your
Monetary
account
trail, Lordship. Monetary trail.
by the co-accused.
Yes, Lordship. Monetary
What
trail
is the explanation?
monetary trail is also I am supporting with the judgment of Riya Chakrabarti, Sushant Singh Rajput's case, Lordship. Page number 58, Lordship. Page number 58, para number 60, Lordship.
Yes.
Lordship. Therefore, simply providing money for a particular transaction or other transaction will not be financing of that activity. Financing will have to be interpreted to mean to provide funds for either making that particular activity operational or for sustaining it. It is the financial support which directly or indirectly is cause existence of such illicit traffic. Lordship, if I have what is the cost of the contraband? If the cost of the contraband is 5 crore or 1 crore, I have transaction 1,000 rupees or 500 rupees. Is it relevant for Lordship? Will I get that amount within the 500 rupees or 3,000 rupees, Lordship? That has to be detailed. That has to be analytically furnished that so and so such and such money was transacted by the co-accused and between me. Lordship.
Yes.
That next, Lordship, I don't have any criminal record, Lordship, as of now. I have been in service for 23 years in CRPF, Lordship. And within these 23 years, I don't have any adverse record against me, Lordship. Then, Lordship, coming to the grounds of arrest, Lordship.
No, do you have any explanation that why you have received money from him?
I have not, Lordship, as per my information, I have not received.
You have not received.
Yes, I have not received. But if I have received, earlier I have stated that he is my professional colleague, Lordship. We are doing the same post. Rakesh Ahmed, Santosh Kumar, and me are in CRPF, radio operator in CRPF. So I may have the friendly relationship. Sometimes I may borrow or lend and 1,000, 2,000, 5,000 rupees. That may be one time or 2 times. It may happen, Lordship. But that is not for the drug smuggling, Lordship. For the purpose of drug smuggling. But that has not been detailed. How many rupees, how much rupees were transacted between me and
Okay. What else?
yeah. The next, Lordship, I will support him to Francis judgment and Pallu Lavit. The next I am coming to Lordship is regarding the grounds of arrest, Lordship. Lordship, kindly come to the page number 25 of my petition, Lordship. It's a memorandum of arrest, Lordship. The memorandum of arrest is duly signed by Jahia Khan.
Yes.
And it is not, I know, I am not fluent in English. I don't have too much knowledge in English, lordship. Then again, one notice has been given to my wife, lordship. That is in page number 28, lordship. Sanathoy Bibi Begum, lordship. The notice has been addressed to my wife, Sanathoy Bibi Begum, but it has been received by Muhammad Akhtar Khan, who relation has been written as a brother-in-law, lordship. From the signature and the handwriting of this person, it is understandable, it's comprehensible that the person does not have knowledge of English, lordship. But grounds of arrest has to be furnished in understand comprehensible language, lordship. And that is given at 8 p.m. lordship on the day of 4th of September, lordship.
No, which notice you want?
This is page number 28, lordship. In under 48, section 48, page number 28. It is given on 4th of September, lordship, to the brother-in-law. I don't know who is the brother-in-law. And
Muhammad Akhtar Khan is not your brother-in-law.
no, lordship. And this is given after the after the production, lordship. Time is not mentioned here, lordship. But as per the latest judgment of Worli hit and run case, lordship, Mihir Rajesh Shah case, the grounds of arrest has to be furnished at least 2 hours prior to the production, so that the accused person can engage his advocate and detail to his advocate, lordship. But that is given after production, lord. And I have
Yes.
Mihir Rajesh Shah, page number 46, lordship, para number 52. A relevant page I have highlighted, lordship. Third, page number 46, lordship.
Yes.
Is later, a written copy of grounds of arrest must be supplied to the arrested person within a reasonable time, and in no event later than 2 hours prior to production of the arrestee before the magistrate for remand proceedings. The remand paper shall contain the grounds of arrest, and in case there is delay in supply thereof, a note indicating a cause for it to be included for the information of the magistrate. No explanation of delay also, lordship. And the place where I was arrested, that is also not mentioned, lordship. Where I have been arrested, but that is mandatory, lordship. Place has to be mentioned. And if the grounds arrest, lordship, communication relate to the family or legal aid, it is not mentioned, lordship. That has to be mentioned, lordship. But these are not mentioned, lordship. Whether I have been medically treated or not, whether I have been considered my family or my family has understood from the signature. By the signature, you have understood that he does not know English, but that has to be in comprehensible language, lordship. That has been in Vihan Kumar judgment, Pankaj Bansal judgment already been stated, and also that has been reiterated in Mihir Rajesh Shah's judgment, which I have given you right now, lordship. These all have been relied. That is Mihir Rajesh Shah judgment. This is the Worli hit and run case, lordship.
Okay, anything else?
So I have ample grounds to enlarge on bail, and only on the basis of suspicion, lordship. And I am the service holder, lordship. There is no flight risk, lordship.
I will not jump the court law. So lordship, and already my service has been dismissed, lordship. It
You
is a
have
matter
been
of livelihood.
dismissed.
Yes, lordship.
Okay.
If I have been made the scapegoat, lordship, if I am acquitted, so will they return my job? How my livelihood will going on?
No, the job can be returned. You can, if you're,
On the basis of suspicion, lordship, nothing has been
okay, let us
nothing has been
not go
recovered.
into
Tufan
those.
Singh judgment is there, lordship.
Okay.
Pallu Labid
Yes,
Arif
Mr.
judgment is there, lordship.
Mr. KL. What is the basis on which he was?
Lordship, case there is, Lordship, I am reading one paragraph from statement of the present petitioner. Everything will be clear. I'll submit. Once my brother-in-law, Muhammad Abdul Matlib, alias so-and-so, who was former Manipur police personnel and dismissed from police, revealed that he is involved in smuggling of methamphetamine tablets. He explained me about smuggling of methamphetamine tablets and offered me to involve in trafficking of methamphetamine tablets to earn huge amount of money. Therefore, I discussed this matter with Rakesh Ahmed, another co-accused, who is also head constable in CRPF and also agreed for trafficking of methamphetamine tablets to Agartala from Imphal in greed of money. Rakesh Ahmed was deployed in Manipur and he was responsible for arrange career. I, along with Abdul Matlib Khan, alias so-and-so, supplies methamphetamine tablets to Rakesh Ahmed, and Rakesh Ahmed arranged carrier Santosh Kumar Tamil Sivan, and Santosh Kumar Tamil Sivan carried methamphetamine tablet from Imphal to Agartala and supplies to Dulal Mia in Agartala, Tripura. Further, Dulal Mia supplied methamphetamine tablets to one person in Bangladesh. I do not know the name of the person in Bangladesh. This is the statement, lordship. Then again, about 15 lakhs has been deposited in account. He admitted. Question was how you were paid the amount of trafficking of methamphetamine tablets. Sometimes the amount was paid to me by cash, and sometimes it was deposited in my SBI account number so. But the further amount numbers 1 to 3 were deposited by Dulal Mia as payment of consignment of methamphetamine tablet. Amount mentioned in serial number 4 was deposited by Rakesh Ahmed. And furthermore, lordship, all the accused persons, they belong to CRPF, the discipline force lordship. For heinous crime they have involved. And 33 kg has been methamphetamine tablet been recovered. And he has admitted everything. And lordship,
No,
furthermore,
apart from his confession, what else is?
lordship, because the investigation is going on, lordship. And Rakesh Ahmed bail application is rejected by this honorable court. Lordship, this is the judgment.
Whose bail application was rejected?
By justice,
His bail application?
no, he is not, lordship, he is co-accused, Rakesh Ahmed bail.
No, co-accused may be involved.
Lordship, no, lordship, he is standing on the same footing. He was arrested subsequently, lordship, on the basis of a statement of Rakesh Kumar, lordship.
No, what my query is,
Lordship.
suppose co-accused statement is there and he has also confessed. Both these evidence are not admissible.
Yes, lordship.
Listen to my query.
For
Listen
the
to.
purpose of
No,
investigation, lordship.
listen to my query
Yes.
first. Let me complete it
Okay.
so that you can answer properly. Only then I will understand. What you have shown is the confession. And co-accused, listen.
Lordship.
Co-accused statement is also a confessional
Yes,
of the co-accused.
Lord.
Whether any further evidence could be collected in 107 days, like verifying the bank accounts.
Yes,
He has submitted that money has been deposited by some
co-accused in his account.
Dulal Mia
Dulal Mia
as
and,
well as Rakesh in his
yes.
account.
That,
These are verifiable facts.
yes, lordship, that has been verified by the.
Whether that is verified,
Yes, lordship, and the further
is
investigation.
there a material on
Yes,
in
lordship.
the
Money trail is there. After his constant statement that was verified, they were found that the amount was deposited in his account.
you flag that? That is a strong piece of evidence.
Lordship, the bank account, Lordship, he is sending in PDF. I'll submit to you.
And that has to be there in the
Yes, sir.
case diary.
Lordship, there are two files. They have sent one file
Okay,
because further investigation going on.
okay.
Lordship,
On the
please-
basis of confession, you further investigated and
Yes,
you
sir.
find
Yes, sir.
corroborative evidence. That is to be placed before the court.
And Lordship, my management relied on two judgment, that is Tufan Singh and Alladi Ahmed. Lordship, that was considered by the Honorable Court while rejecting the bail application of the appeal. Lordship, may I please to see paragraph 12. The judgment passed in bail application 3468 of Rakesh Ahmed.
Yes,
Paragraph 12. On perusal of the document available in the case diary, it is seen that the wife of accused, Srimati Papia Akhtar, was immediately that is with related to so. Then paragraph 13. It is also seen from the record that the wife of the accused had immediately come to Assam and applied for bail. In this case also, Lordship, bail application was filed before the trial court. Then paragraph 14. As far as confessional statement and implication of the accused applicant by the co-accused, namely Santosh Kumar Prasman, is concerned, this court has gone through the statement recorded by NCB officials of the accused appellant as well as the aforesaid accused. It is seen from the confessional statement the accused appellant has admitted of knowing the co-accused, namely Santosh Kumar, since long time when both were working in CRPF. He is admitted of arranging the carrier to carry the seized methamphetamine tablets for two other persons. Accordingly, he was paid rupees 250,000 by the said person for arranging to carry the seized contraband. Therefore, it seems that he himself admitted that he has engaged the co-accused named Santosh Kumar to carry the contraband drugs which were seized by NCB officials. It is also seen from the record that the several amounts of money has been transferred to the account of the accused, namely Santosh Kumar, by the accused so just a fortnight before the seizure of the contraband materials of NCB officials. It is also seen from the record that several WhatsApp messages discussing about the payment of rupees 250,000 to the accused has been discussed between the accused applicant and aforesaid co-accused.
yes.
Same thing is with respect to the.
You flagged
Yes, sir.
that portion of the case diary where there is evidence of receipt of money.
Yes, sir. I'll submit another file today itself.
Okay.
And in the present case diary, Lordship, everything is there.
No, present case diary, confession is there.
Confession and the other materials are also there.
What
Besides
materials?
bank statement that has been verified by the IO is sending Lordship.
What other materials are there?
Other materials, Lordship, that he is involved in this type of incident earlier also. That materials are there. Of course, in the form of the statement.
Statement of co-accused.
The present petition also. I'm reading the statement of
No,
the.
I have understood that in confessional statement, he has implicated himself.
Good.
Co-accused have implicated him. But I am speaking about other evidence which you have collected during these 107
Some
days.
has collected, some are yet to be collected. That already bank statement has been verified and it is proved that the money has been deposited in account by the co-accused.
Okay,
And
that would be a
seriousness of the case is that all the persons arrested are CRPF personnel. This is more dangerous part of this case.
okay. Let me examine.
Lordship.
Hard. Your case is there is no material. Your case is that, and regarding 48, Mr. Kaya,
Learned counsel.
Yes, Lordship, it is
All are,
there.
all confession statements.
All,
All are confession
no,
statements.
I have understood. I have. Regarding 48 is not in the language understood by.
it has been telephonic intimation of arrest. In court form, I said brother-in-law of the petitioner accepted. And Lordship in not fit it is.
No, Mr. Khan's Rahman's submission is that the notice was not in the language understood. What is your
It was
submission?
Explain to both the accused persons and the wife of the petitioner about telephone, Lordship. And that the notice was sent on WhatsApp also.
Lordship, my wife doesn't understand English. So how? It has to be in local language or in comprehensive.
You have made that statement in the bail application
No, Lord.
that your wife does not understand English.
Nothing has been mentioned in.
I
the
have mentioned grounds of arrest are not part of it, but that is not stated.
That's plea you have not taken specifically.
Not specifically, but just I have stated that grounds of arrest are not furnished. So
It is furnished.
grounds of arrest in
And
and that is not received by me, my wife, Lordship. But addressing to my wife, but that is not received by me, by my wife, Lordship. Sanatha Bibi is my wife,
Whether the
but
person,
that has been
the person has received, he has
received
made
by
any statement that he is not
Muhammad
his
Akhtar.
brother-in-law.
Muhammad Akhtar. And from the signature,
No,
it
whether
is
he has,
understandable
petitioner
that
has
he does
mentioned
not
in
know
the bail
English.
application that the person who has received the notice on behalf of his wife is not his brother-in-law.
okay, that is not.
No, Lordship, that was intimated to the wife of the petitioner over telephone as provided by the accused, and that is sufficient compliance as per order passed by your Lordship in case of surveillance.
Telephonic, it is not
And
sufficient.
Lordship, it was sent through WhatsApp also. That we have a screenshot of that WhatsApp also. Lordship, we verified, I think it's available in the case.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. A.C. Kyal, learned counsel for the NCB, learned standing counsel NCB. This application under section 483 of BNSS has been filed by the petitioner, namely Jahia Khan, who has been detained behind the bars since 4/9/2025 in connection with NCB crime number 10/2025 under sections 18C/20C/ 22C/25/29 of the NDPS Act 1985. The gist of accusation in this case is that on 25/7/2025, the officials of Narcotic Control Bureau had conducted a search operation in the Nagaland Express within bracket train number 15670 bracket close at platform number 1 of the Hojai railway station in between 140 hours to 10 hours. And during such operation, how much?
33.667 kilograms. Rubber
30
tablets.
33.66 kg,
667.
667 kg of what tablet?
Methamphetamine.
Methamphetamine tablets were recovered therefrom.
Prime
Uh,
Santosh Kumar.
At the time, the aforesaid contraband was recovered from the possession of co-accused Santosh Kumar. Santosh Kumar and Tamil Selvan are 2 persons or
Not
1
the
person?
same person.
Some
Santosh Kumar Tamil Selvan, full name.
Santosh Kumar Tamil Selvan. Stop. The said accused was arrested from the place of seizure and later on during preliminary interrogation the said accused disclosed that the contraband was what is the role of Rakesh Ahmed?
Lordship, his name was also disclosed by co-AP.
Contraband, then no. Line production last. In interrogation, the arrested accused implicated one another co-accused, namely Rakesh Ahmed, regarding his complicity in the alleged offense. The said Rakesh Ahmed, as well as arrested accused Santosh Kumar Tamil Selvan, were also employed in the Central Reserve Police Force. Later on the basis of the statement made by the co-accused, the present petitioner was arrested on 4/9/2025.
3/9 he was arrested.
Stop 3/9/2025. Learned counsel for the petition, next para, learned counsel for the petitioner has submitted that the petitioner is innocent and is not involved in the offense alleged in this case. He submits that he was arrested from which airport?
Guwahati Airport.
Guwahati Airport.
While I was going from Agartala to Manipur.
When he
I was
was
arrested from the airport, but they have showed it in arrested in.
when he was
NTU,
going from
but that is
Agartala
not
to Manipur.
mentioned in the arrest memo.
He further submits that nothing was recovered from his possession. He further submits that though the seizure of the contraband was made in Ojai, however, on the date of incident, he was engaged in his duty at Agartala, and in support of his submission, he has produced the duty roster of 23/7/2025 to 25/7/2025. He further submits that the present petitioner has been arrested in this case merely on the basis of statement of the co-accused, and no other materials are there against him. He also submits that though the NCB has alleged that the call data reports of the call data records, CD within bracket CDR, of the telephonic conversation between the present petitioner and the co-accused implicates him in this case. He, however, learned counsel for the petitioner submits that as the co-accused were also the employees of CRPF, it would be natural to have conversation with the colleagues. However, he submits that there is nothing on record to show as to what conversation was made between the co-accused and the present petitioner, as there is no voice recording relating to the conversation made between them. He submits that merely on the basis of merely on the basis of CDR, which indicates that the petitioner had telephonic conversation with the co-accused, from whose possession the contraband was recovered, is not sufficient to implicate the present petitioner in an offense regarding possession of commercial quantity of contraband. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court, ruling of the High Court of Jammu and Kashmir and Ladakh in the case of Sarid Ahmed Ghani, GANIE versus Union of India, within bracket, order dated 18/10/2025 in bail application number 21/2025. Learned counsel for the petitioner has further submitted that the petitioner has not received any money from the co-accused, and even if there is any material to show that any amount has been deposited by the co-accused in his account, this in itself would not be sufficient to implicate him in the offense alleged in this case. He submits that since the co-accused were also employees of the Central Reserve Police Force, there may be a few monetary transaction between them. He submits that what is important is the amount of money transacted between them. He submits that mere fact of simply providing money for a particular transaction or other transaction would not in itself be sufficient to show that the said money has been accepted by the petitioner in connection with the contraband which has been recovered in this case. In support of his submission, learned counsel for the petitioner has cited a ruling of the High Court of Bombay in the case of Riya Chakravarti versus Union of India, within bracket, order dated 17/10/2020 in criminal bail application within bracket S number 2386/2020. Learned counsel for the petitioner further submits that the notice under section 48 of BNSS was not duly served on the relative/friend/nominated person of the petitioner. He submits that on perusal of the notice under section 48, which was served on the relative of the petitioner, it appears that though the said notice was addressed to the wife of the petitioner, namely Sanat Oibi Begum, however, same was shown to have been received by one Muhammad Akhtar Khan, who is stated to be brother-in-law of the present petitioner. Learned counsel for the petitioner submits that the petitioner is not the brother-in-law, and the said person is not the brother-in-law of the petitioner. He also submits that the wife of the petitioner is not acquainted with English language, and there is no indication in the notice under section 48 that the content of the said notice was explained to the addressee in the language understood by her/him. He also submits that the notice to the petitioner was notice under section 47 of the petitioner was served on him after he was produced. This is your submission. After he was produced before the magistrate after his arrest, which is in violation of the guideline of the apex court in the case of Mihir Rajesh Shah versus State of Maharashtra and another reported in 2025 INSC 1288. He also said, any other submission?
Clean record, Lordship, and does not have any involvement. in
Learned
the case.
counsel for the
And
petitioner
he is a CRPF officer.
has
So he
further
is dismissed
submitted
with
that the petitioner has been
clean antecedent.
employed in CRPF for last 23 years and there has been no criminal antecedent against him. And he has been arrested only on the basis of confessional statement made by the co-accused, which is not admissible in evidence in an offense under section under the provision of NDPS Act. In support of his submission, he has cited the ruling of the apex court in the case of Tufan Singh versus State of
Pollul Abid Ahmed Arimat.
Tamil Nadu. Tufan Singh, what is the citation? Reported in dash. Citation. On the other hand,
For SCC.
Mr. S.C. Kayal has vehemently opposed the grant of bail to the present petitioner. He submits that all the accused persons arrested in this case are the employees of Central Reserve Police Force and the material on record clearly indicates the manner in which they have indulged, they have committed the alleged offense. He submits that there are sufficient materials in the case diary, including the confessional statement of the petitioner as well as the co-accused, wherein the modus operandi of committing the similar offenses has been clearly explained. He further submits that in pursuant to the information received by the investigating officer on the basis of confessional statement, during further investigation, the details of bank account of the petitioners has also been collected, which clearly indicates that how much amount? Huge amount.
50 lakhs, 15 lakhs.
But that is not on record, Lordship.
I'm submitting on
Party
the
the
basis of record. Lord.
Case diary is there. I'll verify
Yes, Lord.
that huge amount of money was deposited in the account of the present petitioner by the co-accused, namely Rakesh, from whose account it was deposited.
Lordship, it was deposited from Dulal Mia and Rakesh Ahmed.
And Dulal Mia as well as Rakesh Ahmed.
Lordship, further he has admitted that I have till date I have earned rupees 25 lakhs till date from this.
He further submits that there is a clear confession in the case diary regarding the fact that the present petitioner has earned about
25 lakhs.
25 lakhs by involving in the offense relating to
Trafficking of methamphetamine.
trafficking of relating to trafficking / supply of methamphetamine tablet. He further submits that investigation to verify the same is going on. Learned counsel for the learned standing counsel of the learned standing counsel NCB has submitted that under similar circumstances, a coordinate bench of this court, while considering the bail application by the co-accused Rakesh Ahmed, has rejected the bail application, rejected his bail application. He submits that the present petitioner also stands on similar footing like that of Rakesh Ahmed. Learned, when will you submit the
Today itself, within half an hour.
learned?
For that, note sheet, I'm reading this. He was sub notice 67, he appeared before the authority in the office. In his, it is submitted that Mr. Jaya Khan, son of so-and-so, appeared before the undersigned on 3/9/2025 at the office of the narcotic NCB, VIP Road, Guwahati, for tendering his voluntary statement in compliance with the notice dated, notice under section 67C of NDPS Act by Sri N. Prasad on 2/9/23 was served notice. Then in connection with the recovery of siege of 33.617 kg of methamphetamine tablets on 25/7/25 at CRPF post platform number 1, Hojai railway station, Hojai, from the position of the Santosh Kumar Tamil Sivan, the voluntary statement of Mr. Jaya Khan as recorded under section 67 of NDPS Act at the office of Narcotic Control Bureau, Guwahati. On the basis of his statement, other facts and the available evidence on record, and having reason to believe that Mr. Muhammad Jaya Khan has committed the offense punishable under section 8C, 22C and 29 of NDPS Act, Mr. Jaya Khan was accordingly placed under arrest on 3/9/2025 at 5 hours at the office of the NCB Guwahati. Then the ground of arrest were duly explained to him in language known and understood by him. The Tamil Selvan, the Jamatalasi procedure in respect of Muhammad Jaya Khan was conducted by the undersigned following the due process, and items voluntarily handed over to accused, namely Jaya Khan, were placed 3 yellow color envelope. Then Mr. Jaya Khan has given Lordship under 41, 48 was also complied with. Lordship, I am reading. Mr. Jaya Khan has given information of his arrest to his wife, so and so, telephonically immediately after arrest was made. Furthermore, an intimation letter of arrest dated 3/9/25 in respect of Jaya Khan was sent to his wife via speed post. Additionally, the intimation of arrest was personally served to his brother-in-law, namely Muhammad Akhtar Khan, on 4/9/25 at the court premises, Hojai. The intimation letter of arrest 3/9 concerning Mr. Jaya Khan was also sent via email to the concerned police station and the superintendent of police, Thoubal, Manipur, for necessary information.
Flag.
What more required?
Lordship, their statement is self-contradictory. They have said that the grounds of arrest has been furnished to their wife, to his wife. But they have taken the signature of the brother-in-law. Lord.
What was the last line?
Their statement is self-contradictory. Lord.
Let's see if I'm submitting this.
He has further stated that the content of notice under section 48 of BNSS was made understood in the language, was communicated in the language understood by the noticee. Stop. He has also produced the case diary of NCB crime number, case diary of this case. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the case diary produced by learned counsel for the learned standing counsel NCB. On when will you produce?
Within an hour, Lord. One file is with me, another is coming. It's coming, IO is coming in, is on the way. Along with the bank statement and the inquiry conducted in the bank.
Okay, then I'll
Before rising your lordship, I'll submit to the, through the.
I'll pass orders in chambers,
Lordship,
remaining part.
lordship.
After verifying the case diary, I'll
Lord.
pass.
One time I have.
The grounds of risk may kindly be considered.
If there is a delay in submission of case diary, then on the reopening day. You'll be able to submit.
Today
within-
itself, Lord. One file is with me that I'm submitting, lordship, I've landmarked the necessary.
Profile. Okay, you,
I'm submitting within an hour. One file I am submitting.
okay, remaining part in chamber.
His lordship is coming, lordship will submit. Much.
Obliged.
Item 15.
Yes,
Lordship, the affidavit for service in the newspaper, publication has come.
affidavit has come. You have taken steps for,
On respondent numbers 1A to 1C, 5, 6, 7, and 8.
okay. Heard Mr. K.R. Barua, learned counsel for the appellant. Also heard Mr.
B. Burman, my lord.
B. Burman appearing for responding number 5, 6, 7,
5, 6, and 7.
5, 6, and 7. 7. Stop. Learned counsel for the appellant submits that in pursuant to the directions of this court, the appellant has taken steps for publication of notice in the newspaper. And accordingly, the said notice were published in the news, which newspaper? In the Assam Tribune dated
8/12/2025.
8/12/2025. The date of notice, date of appearance in the said notice has been mentioned in as what is the date of appearance?
Return able date was 12/12/2025.
12/12/2025. So after considering the submissions made by learned counsel for the appellant, as well as after going through the affidavit in compliance and the newspaper annexed therewith, this court hereby holds that notice issued to respondent number 1A to 1C and respondent number 8 are duly served. The service on all the respondents is therefore complete. Case trial court record is there. The trial court record has arrived, and then therefore this regular first appeal is ready for hearing. Release this matter for hearing.
I may be allowed to make one small submission, my lord. So
Yes.
for the respondent number 5 and 6, they have sold out their share of them. That is, I should bring to the notice of this honorable court.
On the date of hearing, you may
Yes, my lord. But the first time today I am appearing, so I have brought it.
stop. Learned counsel for respondent number
5 and 6.
5, 6, and 7.
7 not, my lord. 5 and 6.
5 and 6 has submitted that the said respondent have already sold out their share in the suit property. In the suit property.
Other than names may be furnished.
Yes, my lord, I have a copy of the sale deed, but it is not so legible, but I can furnish. So that they can look at it.
Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry. Oh, newspaper publication 1A to 1C 7 and 8 7 lagai দিব. You are appearing only for 5 and 6.
7 also, my lord.
5, 6, 7.
7
6,
also. There 7 কাটি দিব. ঠিকই আছে, ঠিক আছে. Okay. Yes.
Here in this case, we have filed an interlocutory application for stay of the execution. The stage of regular second appeal is at the my lord, delay condonation petition has not been entertained till today because of non-service upon the respondent number 1. The respondent number 1 was the original different number 1 in the main suit. The suit was filed by
How
the
much is the delay?
My lord, it is only 52 days. Respondent number 1 did not appear before the learned trial court. She did not file written statement, and their claim was against the respondent number 1. The suit was filed by the appellant in the capacity of plaintiff for specific performance of contract of an oral agreement. So respondent number 1 was arrayed as different number 1, and the respondent number 2 was
Special performance of contract of oral agreement.
Well, there was some agreement in between the parties because throughout the time, I was her tenant since 2001. In 2001 itself, there was an agreement because she was supposed to leave Tejpur town and was shifted to Shiliguri, my lord, after the retirement of her husband. So out of that 75,000 we have paid, but though it is to be proved in a trial, this is separate issue. I will take your lordship to the pleadings of the respondent number 2. Respondent number 2 comes up and file a written statement and defending the case on behalf of respondent number 1. Whereas respondent number 1 did not appear, suit proceeded ex parte against respondent number 1, the main defendant. Respondent number 2 comes up with a counter claim.
Where is the condonation of delay application? You have not taken steps.
Well, the original, the address I have
No,
mentioned.
you are not entitled to get interim relief.
Well, I can explain it, my lord. The address mentioned in the regular second appeal, my lord, your lordship, if your lordship peruse the order,
No.
ascertain the address of the respondent number 2, but there is no other address except the address which I have mentioned in the memo of appeal.
No, that you have to explain to the court.
Well, that's what I am explaining. Because of this, my lord, problem, my lord, we could not take steps because there is no other address available with the plaintiff. And the respondent number 1, who is the main defendant number 1, did not even appear before the learned trial court. If I may take your lordship to the pleadings, my lord, made by defendant number 2, who is the subsequent purchaser of the suit land. Defendant number 1, even after receiving notice, did not appear before the learned trial court, did not file written statement, nothing, my lord. Eventually, she appeared at the stage of evidence. Well, your lordship is aware, whatever she states.
As witness.
As witness, my lord. As witness, she comes up with some statement which is beyond pleadings. She did not come along with a written statement before the learned trial court as required under order 8. Now she comes up as a witness and depose before the court that this is the land I sold, this is the land, these are the facts. But these facts.
The issue is you are seeking an interim relief during the pendency of condonation delay application. And in condonation delay application, You have not complied with the
Well,
direction.
I have no other alternative remedy because of
That
the
you have to
address.
inform to the court.
Well, when should I inform? This is the time, my lord, when I will inform before this court. That's why, my lord, this case has been listed. Because of their urgency, they are seeking eviction of my lord, the plaintiff from the house, the different number two. Different number two posing himself as the landlord. Well, my landlord was different number one, who did not appear before the court. I did not have the opportunity to come before this court at the earliest point of time. Had they not initiated the execution proceeding, the question would not have come. Well, it has to be listed before the court. Then only I will get the opportunity to explain why I could not take steps before the my lord to the upon the respondent number one. And respondent number one, if I may complete, my lord. Respondent number one, my lord, willfully avoiding service of notice because she is in Siliguri. She is not interested in the property. She in the meantime sold the land to the different number two at a meager price of 50,000. When I was offering 1,50,000 in the year 2001, 2008, different number two purchased the land as alleged. But in the counterclaim filed by the different number two, he did not seek any declaration of right to interest over the suit property. He straightway came up with a impression that he is the landlord. Suddenly, after 2008, when I was there since 2000 as the tenant of different number one, 2001 there was an agreement. Now he is claiming he purchased the
No,
land.
we are not going into these issues.
But so far as the explanation is concerned, when I will get the opportunity to explain that why I could not take steps, there must be a my lord, listing of the case.
Suppose case is not listed.
Well, suppose, my lord, this is the difficulties going on nowadays, my lord. If we mention before the court, then we are directed to the registry. In the registry, bunch of applications are pending. We are also helpless sometimes. And had this situation would not come up, my lord, I would not have been pressing before this honorable court. Because what they have done in the guise of execution, they have put the house, my house under lock and key. Where should I go now? Before I get the opportunity to explain, well, I need to have some opportunity before the honorable court. It was last listed in the year 2024, November. Then we took steps. Then it was service was not complete. Then there was a direction to find out, ascertain the correct address. But there is no other address available. And this is the address which is given in the plain, in the counterclaim, everywhere.
Yes, Ms. Bhattacharjee.
Lordship, the matter was listed, I think 3-4 times, Lordship, and this is the submission that are forwarding is absolutely a new plea, Lordship. This has never been forwarded before this honorable court.
No
of the
occasion
last-
arises before
Lordship,
that,
I have not
Don't
interfered.
don't
Yes. So on last occasion, the honorable court has directed to find out this and take steps upon the defendant lordship, respondent. So absolutely a new plea is being taken by them and with all that means misleading statement. The today's IA that they have asked for the stay of the execution. This has been filed before this honorable court. I have total objection, Lordship, if the delay is been considered on this.
What is the stage of execution case?
It's already complete, Lordship.
Execution is
Yes,
complete.
Lordship. Yesterday, I think I could get this from the website, Lordship, of the e-court. I could not get the because the order is not uploaded. I could not contact my client, Lordship. And this is the status, Lordship, which is displayed in the e-court, Lordship.
So if execution is complete, what we will
So
see?
what is the mode of execution? They have put my entire house with my belongings under lock and key. This is the status of my lord execution yesterday. It was listed on 5/12, then on 18/12, when before I filed this petition, I had to mention it, I had to request it before the registry to list it. My lord, today it is listed. Yesterday on 18, my lord, the learned magistrate had disposed of the execution proceeding, which is the mode of execution. They have put the entire house with my belongings, where I had been residing since 20 years under lock and key. And what are those misleading statements? Let my learned friend explain before this honorable court, which statement by way of which statement I misled this honorable court. Regarding the service of notice, after the observation by this honorable court, it has listed for the first time now, where I am explaining, my lord. There is no misleading statement. I don't want to win or get any order by of any suppression or misleading and the court of law, my lord. This statement may be withdrawn by the learned counsel, my lord. When they don't have any defense, plausible explanation, they comes up with these kind of words, misleading
Say item
statements.
number.
Lordship, if this is, then where are the photographs, Lordship?
Why should
They
I
have-
annex the
yes,
photographs?
they
It is
have
your
to.
duty to bring the photograph
Why
before the
should
honorable.
I bring?
I am stating on oath.
Whatever is there, I have brought
I'm
before
stating
this
on oath.
honorable court.
You don't even have a contact with the client. Now you are urging me to get the photographs. You get the instruction from your client.
Why should I? It is available in the e-court.
Then I
It is
have stated
available
on
to
oath,
publish.
then this to be taken into consideration if you don't have any instruction.
If they are so persisting, Lordship, why they have not? Because the matter was lying, that means not listed for, I think, 1 year, Lordship. If they have so much of urgency, they could have get it listed, Lordship.
Right, judges, stop quarreling amongst yourself. Yes.
But the situation arose
Now,
after 5 months.
listen to me. You have spoken too much.
Yes, my lord.
Now answer the query of the court. In I dealing with the condonation of the deal relating to condonation application, the notice is not served. What is to be done in that case?
But a notice is not served. Respond number 2 is appearing, and respond number 2 is taking entire step before the executing court. And different number 1, who is the respondent number 1 here, did not appear before the learned court, my lord. Did not file written statement, did not contest. She came once for adducing evidence. And it is the different.
So notice should be waived.
But notice, my lord, I am not seeking for waiver of the notice, my lord, for the proper adjudication of the case, because since she did not appear before the learned trial court, not in trial, not in first appeal, my lord, I don't think that, my lord, she would come and appear before this honorable court, but I am not seeking any waiver of the notice. I will
No, there is
pursue.
a provision in the CPC.
Yes, my lord,
Yes.
that
there is a
when-
provision. There is a provision. But I am for the ends of justice, I am not seeking that too also.
That what you are saying.
Well, I have to, matlab, the address, whichever address is given in the plane, I have inquired. This is the only address.
No, I don't want your explanation.
Then, matlab,
I
then
want
notice may
your
be waived. Notice may be waived
I
because
want your submission. What is to be done?
matlab, notice may be waived then on respondent number 1.
Or you find out, you know the address of the respondent number 1.
Lordship, in that case, I have to take instruction, Lordship. Because today also I tried to contact my client, Lordship, but I could not get it. Maybe due to
And
connection problem
and
or something like.
You find out
even if the delay is not condoned, there is a judgment of our
we are
honor.
not going into those questions. We are on a particular issue. Let us first decide that issue. Then I'll come to that. Heard Mr. S. Vishwas. Learned counsel for the applicant. This is in IA number 3861/2024. Learned counsel for the applicant. On perusal of the office note dated 11/12/2025, it appears that no steps have been taken by the petitioner in pursuant to the directions of this court by order dated 25/4/2025. Stop. Learned counsel for the petitioner has submitted that the petitioner does not have any alternative address about of the respondent number 2. It appears that said plea has been taken. You took this plea earlier?
Then, my lord, I tried, my lord. There is
No, there
other-
is no indication in the order sheet.
There is no indication. I asked the court, my lord. I will try, my lord, but I contacted because the local council is from.
He further submits that he on last occasion also he had submitted before the court that he will try to find out the current address of respondent number 1. However, he failed to do so. Learned counsel for the applicant further submits that some more time may be granted to the applicant to find out correct address of the respondent number 1. And thereafter, he may be allowed to take steps for issuance of notice upon the said respondent. The prayer is allowed. The petitioner shall find out the current address of the respondent number 1 and shall take steps on the new address within a period of 7 days from the date of this order, returnable on
7 days, my lord, from
opening.
tomorrow onwards.
The registry will be open in between. Only 7 working days.
We may not be able to collect the address, my lord, because we tried since 1 year.
How much time?
Well, in the reopening, my lord. Otherwise, my lord, I am submitting, my lord, there is no other address available of the different number 1, respondent number 1. And this is the only address.
Then what is your submission?
Then her, my lord, this appearance may be waived, my lord, as per the provision. Because
Which
she
provision?
did not contest the case, my lord.
The
And she,
agreement was between whom?
between the, my lord, the plaintiff and the different number 1, the respondent number 1 here.
You and
Yes. And
you and respondent number 1.
1. And
Then how the notice can be waived?
she did not even contest in the trial. She did not file written statement. She did not contest in the first appeal. She rather filed a counterclaim, and the decree is on the counterclaim. Now she is trying to execute the counterclaim.
Quote the provision. Order 41, Rule 14.
Yes.
Learned counsel for the petitioner submits that since the petitioner is not able to find out the alternative address of the respondent number 1, and since the respondent had not contested the suit before the trial court and also did not contest the appeal before the first appellate court, the notice to the said respondent may be waived. You have any objection?
Lordship, if their submission is so, Lordship, this must come with a proper application, Lordship. My humble submission before your Lordship.
We'll consider this a prayer on, you make one attempt to find out.
My humble submission, I have made several attempts, my lord. This is the only address available. There is no
When
other
have
address.
you made attempts?
Whereas in the last 1 year, I asked yesterday also, day before yesterday also, the council in Tejpur, because she is in Shiliguri, West Bengal. The lady, my lord, different number 1, after my lord selling out all the property, she left.
It is not difficult to find out address of a person.
But these are the address which is mentioned in the plain WS counterclaim, and decree they are executing, it is the counterclaim filed by respondent number 2. Counterclaim is for eviction.
The prayer for waiving the notice on respondent number 1 shall be considered on the next date. In the meanwhile, learned counsel for the petitioner is directed to make an attempt to find out current address of the respondent number 1 and take fresh steps for issuance of notice on the said respondent within 7 working days, within 15 working days, within 7 working days, returnable on dated 2nd of February. This interlocutory application has been filed under Order 41 Rule 5 of the Code of Civil Procedure 1908 for stay of entire proceeding of title execution number 67/2024. Learned counsel for the petitioner has submitted that though the petitioner has impugned the judgment of the trial court as well as the first appellate court in the connected regular second appeal stop. However, since there was some delay in filing of the connected regular second appeal, an interlocutory application for condoning the delay has been filed. He submits that in the said application for condoning the delay, which has been registered as IA civil number 3861/2024, the matter has not proceeded as the notice of the said interlocutory application is yet could not be served on the respondent number 1, as the said respondent is not available in the known address of the available in the address known to the present petitioner. He further submits that during the pendency of this proceeding, the decree holder has proceeded with execution of this case, execution of the impugned decree, and as the suit premises is the place where the present petitioner stays, execution of the decree is required to be stayed immediately. On the other hand, Ms. M. Bhattacharya, learned counsel for respondent number 2, has submitted that this application has become infructuous in as much as the title execution case number 67 has already been disposed of after execution of the decree. In support of her submission, she has produced a screenshot of the status of the title execution case number 67/2024 downloaded from the e-court website of the e-court. What is to be done now?
The difficulty is that in the past interlocutory application, with the permission, if I may submit, as per order 14 rule 2, I may be allowed to serve the copy of the respondent number 1 to the pleader, my lord, in the learned trial court. And the decree, my lord, which has been executed, the decree is in favor of respondent number 2, not in favor of respondent number 1, because respondent number 2 filed a counterclaim for my eviction. So far as stay of decree is concerned, my lord, both the parties are appearing, my lord, because decree which now she proceeded with is a decree obtained by the respondent number 2 in the counterclaim. Respondent number one did not file a written statement. She did not have any counterclaim. And what is the decree for eviction? Well, your lordship is aware if for the
No,
timing.
don't go stray from your line.
Okay.
You will, after I dictate
I'm
order, you
coming.
will make another submission.
No, I'm coming to the point. Now the entire house along with my belongings has been put under lock and key, my lord. Now I am unable to enter my house. So to that extent, my lord, the lock and key.
Will call for a report from the
Lordship. Lordship.
executing court. Whether with belonging, whether what you are submitting is true or.
Yes, ma'am, because this is my rented premises and I have been residing there since 2000. I have no other alternative, my lord, to live in, my lord. And the report, my lord, it will come, my lord, after the vacation is over. To that extent, my lord, if the lock and key is removed, my lord, at least I'll be able to remove my belongings, my lord, which are under lock and key. And this is showing dispose of because yesterday, my lord, 18/12/2025, my house was put under lock and key. This is the eviction. My lord, your lordship is aware in the landlord-tenant matter, if assuming for the timing, one cannot be evicted in this manner. There has to be a time given that you search for alternative, then you leave the house. There is no other indication in the order, nothing. Just report was called for. Then yesterday, police person went and put the house under lock and key. This is the mode of execution. And she is not the.
No, apart from your submission, there is nothing on record to verify.
Here,
Rather,
I have annexed the order. I have annexed the order in the interlocutory application. How the execution was proceeded. This page 18. And what is the reason my condemnation petition is pending? As no stay order is passed in regard to this execution case, does this court deem it fit to proceed with instant case?
No, that is not the question. Question is whether the decree has been already executed or.
This is the execution. They have put the house under lock and key. This is the mode of execution. I am submitting on oath. And what was the decree? Only eviction. She did not even try seeking.
Where is that oath?
But
Where is that statement that it was put in lock and key?
Well, because I filed the petition, well, I was.
You are changing your stance.
This petition was filed, well, 4 days before, and I was put under.
Last. We can allow if your belongings are.
Yes, my lord.
You can take back that
Yes,
belonging.
I am obliged, my lord, to that extent.
Allow him to take back his belonging.
If your lordship please.
Stop. Learned counsel for the petitioner submits that the execution has been effected by putting lock and key. Execution of the decree has been effected by putting lock and key in the suit premises. He further submits that the belongings of the present petitioner is inside the suit premises and he may be allowed to take back the said belongings. Learned counsel for the petitioner, learned counsel for the respondent does not oppose to this limited prayer. The petitioner is allowed to take back the belonging take back his belonging from the suit premises under the supervision of an officer of the court to be appointed by the Court of London, Civil Judge Junior Division number 2. Let also a report be called for from the Executing Court of Civil Judge Junior Division number 2 regarding the fate of the execution case number 67/2024. Issue notice to respondent number 1 by speed post as well as by speed post within the petitioner shall take steps for issuance of notice upon the said respondent within 7 days from the date of this order returnable on what was the earlier 2nd of February. Since Miss M. Chakravarti, M. Bhattacharya has appeared for respondent number 2, no formal notice need to be issued to respondent number 2.
Lordship, I just want to add, Lordship, on production of the certified copy before the executing court and also with an intimation to the judgment debtor.
Yes.
Judgment debtor is respondent number 2.
Yes, sir.
She is here, my lord, she can inform. And
I
so-
shall inform,
and-
but from the court, when this
Yes.
will be fixed, Lordship, this I shall not know.
I will make some corrections.
Lordship,
The
Lordship.
the petitioner will be allowed to take back his belonging in presence of an officer of the court and on prior intimation to the decree holder.
I will take steps, my lord, in the alternative as per order 41, rule 14, I may be allowed to serve copy to the learned pleader also, my lord, of the respondent number 1. Because they are taking steps, the lawyer is taking step before the learned trial court. He would be in a better position to inform, my lord. Well, it is as per the provision of order 41, rule 14. Your lordship may exercise the discretion, my lord. Because otherwise, my lord, the same situation will arise. What I have submitted, the address is only this address is known to us. There is no other alternative address. So I will take steps alternatively, my lord, in two mode, my lord. I will take steps.
You
and
cannot make submission at one go.
I have submitted earlier, my humble sub.
The petitioner is also allowed to take steps for issuance of notice on respondent number 1 by serving the copy of the said notice to the engaged counsel for respondent number 1 under order
41, rule 14.
order 41 rule 14 of the Code of Civil
Much of-
list accordingly.
much of-
Deeply obliged, Lordship.
34.
बाकी भी लो। Yes.
Yeah, please, Lordship. This IA is filed for condemnation of delay of 771, Your Honor.
Mr. R. Sensor,
R.A. Lahokar.
R.A. Locker, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the petitioner for condoning the delay of
771.
771 days.
Submission was that one partition has already taken place earlier, post the death of both the father
Okay,
and
I
the
can
mother.
recollect. Heard Miss R. Chaudhary. This is item number
21.
21, Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr. N. Chaudhary, learned counsel for the respondent. Both the parties for counsel for both the parties have submitted their written gist of their argument as was directed by this court by its order dated 11/12/2025. The hearing concluded, judgment reserved.
A little bit of change in my argument, Lordship, that I have incorporated in my head. Obliged. Change for this. No,
40? 14. Yes, what is this?
The Lordship may kindly take up the item number 31, my lord.
Item number 31.
Chief Appellant herein, my lord. The suit is for declaration that the plaintiff has right, title, interest and possession over the suit land, my lord. And for declaration that the defendant number 2 has had no right, title, interest or possession over the suit land. For a declaration that the sale deed number 627 dated 23/4/2013 is illegal and void, and for permanent injunction. The case, the brief text of the case of the plaintiff's plaintiff's father made a gift deed of in respect of 28 acres of land. In 28 acres, there 4 acres of land is of the plaintiff's mother. That is also gifted by the same gift deed, my lord. And after getting the gift deed, the property was distributed amongst the plaintiff, pro forma defendant, and the defendant number 3, my lord.
Plaintiff's father gifted how much land?
28 acres.
To
To the plaintiff, defendant number 3 and the pro forma defendant, my lord. In 28 acres, 4 acres of land is the mother of the plaintiff, my lord.
okay, thereafter what happened?
Thereafter, after getting the gift deed, the land was divided amongst the donee, my lord. And in the said gift deed, there are 3 schedules, my lord. In the schedule number 3, there is 13 bigger, 3 cutter, 15 letter. That is the schedule of the schedule A of the plaintiff, my lord. And the suit land is schedule B, 1 bigger, 1 cutter, 9 letter.
Yes.
After partition between the 3 brothers regarding the schedule 3 of the gift deed, the suit land falls under the share of the plaintiff, my lord.
Plaintiff means present appellant.
Present appellant, my lord.
Okay, thereafter.
And the defendant and the plaintiff got mutation in their name, my lord. And the defendant number filed filed a title suit number 71 of 2010. And herein the I have which was exhibit 4 in the I have submitted the in my additional affidavit the exhibit 4, my lord. Additional affidavit, my lord, which I have filed later on after filing of the appeal. Number 128, my lord, additional affidavit.
What is this? Plaint.
Defendant number 1, defendant number 2 filed one title suit 71 of 2010. Earlier to that suit, my lord, earlier to my suit.
Okay.
In additional affidavit, page number 128, my lord.
Yes.
And herein the defendant number 1 admitted in paragraph number 1 of the plaint that the plot of land measuring 1 bigger, 1 cutter, 9 lesser only covered by Patta number 141 of Dag number 130 situated in Revenue Village, Rajapani, Noaville under Srijangram Revenue Circle, PS Abhaypuri District, Bongai, Assam is the subject matter of this suit. Then your lordship may come to paragraph number 2 that the mother of the plaintiff and the defendant named late Sukhjan Nessa was the original owner and possessor of the suit land. Said Sukhjan Nessa died in the year 1989, and after death of said Sukhjan Nessa, the suit land has fallen into the share of the defendant. Accordingly, the record of right was also been corrected in the name of the defendant. That is present appellant, my lord. That during continuous of the possession of the suit land, the defendant sold the suit land to the plaintiff at an amount of rupees 6,000. I have claimed the suit property that I got the suit property by gift deed, my lord. But the defendant denied the gift deed. They said that I got the suit land from my mother, and after during continuous possession, I got my name was mutated, my lord. And the defendant and the present defendant purchased the suit land from the plaintiff, my lord. And in that suit, my lord, the present defendant.
The subject matter of this 1971 No, this 71/2010 and your suit are same.
Since
Same.
that suit was dismissed below,
Okay, that suit was dismissed.
for not taking steps, my lord. And in that suit, the present defendant number one did not get any injunction, my lord. Regarding possession, did not get any temporary injunction. Later on, this suit was dismissed. Later on, during the pendings of this suit, the defendant number two sold the suit land to the defendant number one, my lord.
Pendency of which suit? The
Yeah, the
45.
Title suit number 71 of 2010.
Okay.
And I came to know of this fact, my lord. In my plaint, I have stated in paragraph number 12. Plaint 68, my lord, of the memo of appeal. Paragraph number 12, my lord. Operative page is 71, my lord. Paragraph number 12. That the plaintiff, like previous year, had been tilting the suit land and for preparation to plaint Iradhan on 2/7/2013 at about 10 AM, when the plaintiff had been tilting the suit land along with his sons and some engaged laborer, the defendant number 1 and 2 with some bandit persons armed with deadly weapons trespassed the suit land, assaulted the plaintiff and his companions. Both the parties stood face to face and defendant had dragged the plaintiff by force out of suit land and assaulted him. But luckily, due to intervention of some neighbors and well-wishers, no serious occurrence took place. The plaintiff, being afraid of the possible attacks by the defendants, are compelled to retreat therefrom. The defendants also left the place due to approach of huge number of people in the suit land. On that day, that is on 2/7/2013, the defendant number 1 expressed for the first time that he purchased the suit land from the defendant number 2 by registered sale deed, and the defendant number 1 claimed right title interest over the suit land. He also threatened the plaintiff with dire consequences of his life if he plaintiff again comes to the suit land in future. On 2/7/2013, the plaintiff was in possession, and for the first time, the threat to dispossession comes. Therefore, the filing of the suit cause of action accrues on 2/7/2013.
The sale deed is dated.
Sale deed is dated
Sale deed which you are challenging.
just a minute.
When?
23/4/2013.
Okay, then what happened?
And thereafter I filed the suit, and in the subsequent para I have stated when after getting the certificate copy of the sale deed, I came to know that the defendant number 2 got a patta
Okay. In respect of the suit property.
in respect of this suit
Suit
property.
land.
Respect of the suit property. Therefore, thus my title was clouded. Therefore, I filed the suit for right title declaration. And since I have in possession, therefore I filed a permanent injunction.
What happened?
And the trial court granted me injunction, my lord.
And declared
Temporary injunction.
No, finally what happened in this suit?
Finally, the
Whether suit was decreed or dismissed?
dismissed, the trial court held that my defendant number 1 stated that he purchased the suit land, but did not produce any sale deed. Therefore, the learned trial court said the oral sale deed is not, since it is not registered, because the value of the suit land was above ₹100. Therefore, section 54 is a barred, my lord. Therefore, the learned trial court held that no title was passed. But since the defendant number 2 was in possession, got the mutation, and patta, his title was declared on the basis of the mutation and patta, my lord. And appellate court also held this on the same line, my lord. And appellate court is since I have not challenged the patta within.
What was the observation regarding possession? What trial court held? Who is in possession?
The trial court and appellate court on the basis of the mutation declared the possession of the defendant number two over the suit land, my lord.
Suit land is an agricultural land.
But
Now,
the,
now what is your substantial questions?
and they have taken the place since I have not challenged the patta. Suit is not maintainable, and since I have not challenged the suit within limitation, the suit is barred by limitation, and the appellate court and the trial court both held that suit is barred by limitation.
Barred by limitation.
Barred by limitation, since I have not come within the 3 years of the
3 years of the sale deed.
3 years of the entry of
Mutation.
mutation was mutation, and as well as the patta issuance of patta, my lord.
Now, what plea, what is your stand?
Submitted a substantial question memo, amended memo of appeal, my lord.
Why 2 appeals were filed?
The defendant number one filed one counter claim.
What happened to that?
Counter claim was declared, my lord.
Was decreed. Okay. So against that, you are.
The trial court for finding regarding whether the plaintiff has right title and interest over the suit land by virtue of gift deed number dated 702 dated 7/2/2019. The trial court finding is page number 55, my lord. Paragraph number 10. Paragraph number 10, my lord, page number 55 of the memo of appeal.
Yes.
Now, upon consideration of the evidence as well as pleading, it reveals that Exhibit 5 is not proved as per Section 68 of the evidence. Exhibit 5 is the gift deed, my lord, of the Evidence Act 1872 by calling its attesting witnesses. Further, the contents of Exhibit 5 reveals the same was not executed by the owner of the property, that is Sukhjan Nessa, mother of the plaintiff, defendant number 3 and pro forma defendant. And so for the real owner of the property in question was Sukhjan Nessa, and as such she should have been gifted the property and not her husband. Therefore, I am of the considered opinion that gift of the property of Sukhjan Nessa, mother of the plaintiff, defendant number 3 and pro forma defendant was not validly made. As such, plaintiff could not claim right title interest over the suit on the strength of Exhibit 5. According, this issue is decided in negative against the plaintiff. Your lordship, assuming but not admitted, I did not cite it on the strength of Exhibit 5. But I am the legal heir of my mother. On his death, I will inherit the property, and the defendant number 2 was also admitted that I have the right title interest over the suit land, my lord. Therefore, therefore the learned trial court wrongly held that I have no right title interest over the suit land, my lord. I may not acquire any right title over the by virtue of gift deed, but through inheritance, and the defendant number 2 also admitted my title over the suit land.
And the sale deed was, which you are challenging, was
Defendant number 2 made sold the suit land to the defendant number 1, million. See, if the defendant number 2 had no right title interest, how can he make the sale deed, million?
defendant number 2 is your brother,
He's my step brother, million.
step brother. So your claim is that you also have a share in that property.
But 2 also admitted that suit land fall in my share, million. And their stand is they purchase the suit land from me, but no registered sale deed. And your lordship may
Why your prayer for cancellation of sale deed was rejected?
since defendant number 2 has right title, right title and interest was declared on the basis of mutation and patta. Therefore, the defendant, the sale made by the defendant number 2 is a valid one, my lord. And your lordship may kindly come to page number 57, paragraph number 17. The trial court findings. Now upon consideration of the pleading of the plaintiff, I agree with the plaintiff that alleged oral sale in respect of the suit land could not confer title upon the defendant number 2. Because as per section 54 of Transfer of Property Act 1882, sale of immovable property more than ₹100 is to be made by an registered instrument. But the plaintiff, that is PW, during cross-examination, that the name of the defendant was mutated in respect to the suit land in the year of 1991. He also admitted that in the year of 1991, his mother was alive, meaning thereby that he admitted the delivery of possession of the suit land was made in the year of 1991. From the deposition and conduct of the plaintiff, it reveals that he is well aware about the fact that
Okay, where is your substantial question of law?
in my amended memo of 18, my lord.
Page number?
Uh, Your your lordship, may in our page 4, my lord. My amended memo of 18.
Not in additional affidavit.
No, I have filed in one memo on the, with the liberty of the court, I filed one memo, amended memo of 18. Wherein the substantial question is not here. Your lordship, got it.
Amended memo of appeal. You read out.
First section, whether the learned trial court as well as appellate court were correct in holding that the plaintiff has no right, title, interest over the suit land, my lord. Number 2, whether the learned courts below were justified in declaring the title of the defendant number 2 over the suit land on the basis of the entry made in the revenue records in complete disregard to the established principle of law that such entry is not conclusive proof of title. Then whether the judgment passed by the learned courts below are perverse and outcome of complete misreading, misinterpretation of the evidence on record divorce the pleadings of the plaintiff. Next, whether the learned courts below were justified in holding that the suit of the plaintiff is barred by law of limitation. And number 5, whether the findings of the learned court below regarding possession of the defendants over the suit land is contrary to the materials on record. Defendant number 2's title was declared only on the basis of the entry made in the revenue records.
Yes, Ms. Chaudhary.
Yes, Lordship. I have filed caveat in this matter. Thereafter condemnation was there. Lordship, I filed my objection and condemnation was allowed, Lordship. The first substantial question of law, Lordship, whether the learned trial court as well as appellate court were correct in holding that the plaintiff has no right, title and interest over the suit land. In fact, both the courts never held that the plaintiff has no right, title, interest over the suit land. Both the court held that the plaintiff cannot prove his right, title, interest over the suit land on the basis of Exhibit 5 gifted.
Okay.
By inheritance, he has right title, that also we have admitted, Lordship, in our written statement. So this substantial question will not be applicable in this case. Lordship.
Where is the finding of the trial court regarding
Trial court,
right?
Lordship, that is issue number 6, Lordship.
Page number? 55.
55, Lordship.
Where is the finding?
10, paragraph 10, last 2 lines, Lordship. As such, plaintiff could not claim right, title and interest over the suit land on the strength of Exhibit 5. And on the starting of this paragraph 10, your Lordship will find now upon consideration of the evidence as well as pleading, it reveals that Exhibit 5 is not proved as per Section 68 of the Indian Evidence Act.
What was the issue?
Whether the plaintiff has right, title, interest on the basis of gift deed. Page 54. So both the courts decided accordingly as per law on the issue number 6. So there is no perversity, Lordship. plaintiff failed to prove his right title interest on the basis of gift deed. But by inheritance from his mother, he is entitled for his share.
That
am
you are
step-
also admitting.
That I am admitting in my written statement, also in the plaint of the earlier title suit also.
Then
I
there
am
is,
the stepbrother. I am not entitled for any share from my mother, lordship, as the mother is plaintiff's mother, lordship. I will inherit from my father, lordship. Both the courts held that the gift deed was executed by
mother's
father,
property go only to daughter
her children.
or to her children.
I am from other mother.
Okay,
lordship.
okay.
And father gifted the property, lordship. Both the courts held that as he is not the owner of that 4 bigha, so he cannot give this property.
Yes, that is also right.
Yes, lordship. Both the courts correctly held there is no perversity, lordship.
Okay. Then
Then number 2, lordship, that is substantial question of law number 2 is whether the learned courts below are justified in declaring the title of the defendant number 2 over the suit land on the basis of the entry made in the revenue records in complete disregard to the established principle of law that such entry is not conclusive proof of title. I also agree that on the basis of mutation, a person cannot claim title. But here in this case, what happened, lordship, he was under some debt. The defendant number 2, being his brother, helped him by giving 6,000 rupees. And thereafter, a family settlement took place. And at the end of the family settlement, he himself, plaintiff himself, went to the revenue court, revenue authority, before the revenue authority, put his signature in the revenue records and allowed the revenue authority to record the name of defendant number 2. That was also admitted by plaintiff in his cross, lordship. My learned friend has annexed the cross-examination of PW, that is page 112, lordship.
so it is not a, it is by way of relinquishment of his.
Yes, lordship, relinquishment of his name in the revenue record. He allowed to record the name of the defendant number 2 in the year 1991, and thereafter he remained silent for 22 years, lordship. So both the courts held that suit is barred by limitation. So if suit goes, lordship, the plaintiff has nothing. He will not get anything from that suit, lordship. That is already admitted by plaintiff, lordship. In cross part, page 117, your lordship will find it is a fact that the suit land has got mutated in the name of defendant number 2 in the year 1991. So it was within his knowledge that in the year 1991, the suit land was already mutated in the name of defendant number 2. He allowed defendant number 2 to remain in possession, and thereafter, since 1991, he was in possession, and 2013, he sold out the land by way of a registered sale deed. So both the courts held that the registered sale deed, it was exhibited in an original. So both the courts held that the defendant's number 1's counterclaim on the basis of registered sale deed is proved. So the decree of right title interest of the defendant number 1 over the suit property
No,
was
but
declared.
the Schedule B land was mother's land.
No, lordship, mother's land inherited by plaintiff. I helped him, defendant number 2 helped him by giving 6,000 rupees. Thereafter, family settlement took place. As per family settlement, plaintiff went to the revenue authority, put his signature, allowed to record my name since 1991. Then till 2013, the defendant number 2 was possessing. And then 2013, lordship, he sold out the land to defendant number 1 through a registered sale deed. From 1991 to 2013, the defendant number 2 already got his title through adverse possession also. And your lordship is very well aware about the Ravinder judgment. It says that plaintiff can claim his right title on the basis of adverse possession also. So defendant number 2 perfected his title by way of adverse possession. The plaintiff is silent, lordship. He never
But
objected.
regarding adverse possession, there was no observation.
No, lordship.
By
It is
the-
held that possession was with the defendant number 2. Plaintiff admitted that, so the suit is barred by limitation. And by way of lordship, the recording name of the defendant number 2 in revenue records He perfected his title, lordship. That was admitted by both, that was finding of the courts, lordship. That issue is there, I will read the issue, lordship. Whether the defendant number 2 had right title interest over the suit land, issue number 8, page 29 by the first appellate court, lordship.
Now suit land is how much the area? 4 katha,
What katha 4 lesson?
1 bigha, 1 katha. Yes, 1 bigha, 1 katha, for 9 lecha,
9 lesson, lordship.
9 lechas. That is schedule B land. In whose possession this land is?
Our position. We are saying our position.
Court,
the
court,
held in our position.
court has confirmed your,
Yes,
in,
lordship.
in the counterclaim, was there any prayer for confirmation of
Yes,
possession?
Counterclaim for right title interest and confirmation of position.
So possession has been confirmed.
Yes, lord.
I am still in possession, Mila.
Page 84, your lordship. That the defendant number 1, the counterclaimant, therefore prays for the following relief. For a declaration that the defendant number 1 has every right title interest over the suit land. For a
No,
declaration.
but your suit was for recovery of possession.
No confirmation. Our
Confirmation
suit
Your,
was
your suit,
It's also for confirmation possession.
that was dismissed.
And
Okay.
possession of the defendant number 2 was declared on the basis of mutation entry, Mila. That is wrong, Mila.
That mutation, which mutation plaintiff
Where is the observation regarding confirmation of possession? In your favor, defendant number 2.
issue number 8, lordship. That is issue number 8 by page 56 by trial court, lordship. Moreover, lordship, the defendant number 1 exhibited some documents. Plaintiff did never cross-examine defendant number 1. So both the courts held that defendant's evidence remained unrebutted, lordship. Page 57, first paragraph. Paragraph 16, page 56, your lordship will find last page, lordship, last paragraph. Further, DW1 deposed that the plaintiff had transferred the suit land to defendant number 1 on consideration of rupees 6,000 only. The delivery of possession of the suit land was immediately given to the defendant number 2 and the name of defendant number 2 mutated in respect of the suit land by subtracting the name of the plaintiff in the year of 1991. Since then, the suit land was openly and continuously possessed by the defendant number 2, and in the year of 2010, during second settlement operation, Khiraji Patta in respect of the suit land was issued in the name of defendant number 2. For proving the said fact, DW1 proved the certified copy of Jamabandi in respect of the suit land as Exhibit C. The evidence of DW1 remained unrebutted as the plaintiff failed to cross-examine him. So there is a finding about adverse possession also in favor of the defendant number 2. Though it is not specifically stated that adverse possession, but lordship, it says that openly and continuously possessed by the defendant number 2.
Now, if your possession was confirmed,
Lordship.
then why execution?
Lordship, execution by beating drum in the area that the decree was in favor of the defendant number 1.
Only that much.
Lordship, there's a declaration we have sought for a right title interest in the counterclaim. And if in during execution after decree of the first appellate court, if any third party is occupying the suit land, that the executing court at the time of execution of the decree can evict those persons, lordship.
What is the status of execution case?
Execution case, lordship, notice was at the flag and
2026, already read has been issued, my lord.
Or- Read cannot be for recovery of possession. What?
Writ for recovery means lordship, after execution of the, after starting of the execution proceeding, the plaintiff forcefully occupied the, it's a cultivable land, lordship.
No, there is no pleading.
So when the revenue authority went to the suit land, they found that he is cultivating, so they refrained him from cultivating the area, and then the executing court has issued. Otherwise, since 1991, both the court held that we are in possession, lordship. And the trial court also discussed that oral sale cannot be, defendant number cannot be allowed to remain, cannot be allowed to claim right title interest as per section 54, lordship, paragraph 17. Now, upon consideration of the pleading of the plaintiff, I agree with the plaintiff that alleged oral sale in respect of the suit land could not confer title upon the defendant number 2 because as per section 54 of Transfer of Property Act, sale of immovable property more than ₹100 is to be made by an registered instrument, but the plaintiff, that is PW1, during his cross-examination.
Is there any interlocutory application
Yes, lordship,
in both the cases?
in one case, lordship, in 207.
Common judgment was passed, my lord.
Stay of what? So I
have filed, lordship, caveat, so I object to the stay application, lordship. The second, that's a regular second appeal, which was not supplied to us, lordship. A copy of the regular second appeal, lordship.
will decide on whether substantial question of law is
Fixed it on that any date.
fifth.
If I will submit some judgment, I can also submit judgment.
On fifth, let us hear it again.
Lordship.
And
I'll not,
Until it is admitted, no stay may be passed, lordship.
no stay is granted. Okay. Third, Miss S. Roy, learned counsel for the RSA 207. Learned counsel for the appellant. Also heard Miss R. Chaudhary, learned counsel for the respondent / caveators. You have received the memo of appeal.
Second regular second appeal, item number
Thi-
43. I have.
This one you have,
Item 43, I have 207, I have received, lordship.
learned counsel for the respondent. Both the party learned counsel were heard on the question as to whether any substantial question of law is involved in this case or not. Learned counsel for the appellant has submitted that she may be allowed to produce some authorities in support of her submission and also be allowed to file written submission on the next date fixed. The prayer is allowed. Let this matter be listed again on 5th of
Or after 5th of January, lordship. Can it be on 7th? Then 8th, lordship.
on 8th of January. No part, I will be taking up this matter. Roster will be bench one. It will, and in the, I also issue notice
Then I have to file objection, lordship.
in IA.
Lordship is not yet admitted whether
No,
it is
no.
required to issue notice. Lordship, on 8th, your lordship can issue notice.
Okay, and I, after considering this
Appeal.
appeal,
Otherwise.
no, we can issue notice on
In
the,
appeal, notice was not issued and appeal not yet admitted, lordship. After admission of the appeal, your lordship will take up
No,
the
they-
IA.
Some circumstances may be such when we, before issuing, admitting appeal, in certain circumstances, interim
Yes, sir.
relief may be granted.
The Jain Sharma,
Yes,
Honorable
Section
Justice
51
Jain Sharma,
application is pending, my lord. During the pendency of the condemnation application I filed.
even
Section
during the
Yes, my lord.
pendency of the condemnation application under
Therefore, we are
151.
issuing notice in IS.
Then lordship, I may be allowed to file my written objection.
Since, don't know, I in one case,
One. Only in 207, lordship,
IA number 382 of 25.
382,
337.
since Miss R. Chaudhary has appeared for respondents, no formal notice need to be issued. The petitioner is directed to furnish the copy of interlocutory application. Learned counsel for the respondent submits that she would be filing written objection against the prayer for stay of,
But if so advised, so if they are.
if required, learned counsel for the respondent may file a written objection. The prayer is allowed. Let this matter be listed again on.
Another IA is pending, that is 3379, that was filed during pendency of the condemnation. It has become infructuous as your lordship is issuing notice in 3882.
What is 3379?
Praying
For-
stay
praying for
under
stay during the
151.
condemnation application.
So it has become infructuous. That can be disclosed.
In view of, in 3379, likable, in view of issuance of notice in IS Civil number 3382/2025, this interlocutory application has become infructuous and accordingly disposed of. Let this matter be listed on 8th. Okay, as part of it. 14, same order. 14, along with this application. Heard learned counsel for both sides.
Which one is?
Heard learned counsel for both sides.
337.
List this matter along with RSA number 207/2025.
Verify whether
3379 is
3379 is.
section 121 application.
Sure.
Yes, 3379. And then 3382 is order.
I have written 3379 in
No,
order
no.
41 rule 5
Number
petition.
3379.
3379.
Claim করে নাও, নাহলে confuse হয়ে যাবে।
382 is the order for 41.
3379 is 151.
Then 3882 is for stay.
For stay.
3379 we have disposed of today. 14th list along with RSA number 207/2025 on 8th of January.